added 13,200 qualify for social grants. As the court knows, it's 1,600, and that goes up on the 1st of April, and finally to 17,100 1,700 from the 1st of October. There's also provision for child grants. And when you have an opportunity of looking at the table set out by the panel of experts at volume 8, B293, judges will see that there's substantial provision for veterans and war veterans. The new order from 1st of April 2018, SASSA will make direct payment into the bank accounts of 2.4 million recipients. As the court will appreciate, from Chapter 4 of the second expert's report and further amplified in the third expert's report, the experts consider that the ideal situation is that everybody must have a bank account where electronic payment is made into the bank account. It's a matter which I'll shortly return to. In terms of the agreement entered into on the 8th of December with the South African Post Office, just under 6 million people will migrate into the new system to be administered by the Post Office. That leaves aside 2.8 million people who collect their social grants at pay stations spread out throughout the 9 provinces on scheduled days when people go and collect their cash payments. That system is currently managed by CPS. It involves infrastructural support, which is your logistics to carry the money to the pay stations, the verification exercise, and people are paid. It is that aspect which SASSA was informed on the 8th of December when the Ministerial Committee finalized the negotiations where this contract is being taken over by the Post Office, and it breathes new life into the Post Office, and 5 years later, it will then come back to SASSA. From 8th of December up until the launching of this application, the uncertainty exists over how payments will be made to the 2.8 million people. There's unanimity, there's support from the old minister, the new minister, the 3 other parties before you today, including the 4th party, SAPO, to not oppose the relief which is sought. If the court requires, I can give the references where all the parties, in fact, agree that it is necessary to give the order. CPS, in fact, qualifies it. It says subject to a reasonable fee, and it's a matter which I'll deal with shortly. Before I go on to the cash payment structure going from the 1st of April, just a word about the contract with the Post Office. What this really involves is changing the old SASSA card into the new SASSA card. It's going to be a process because, as the court will appreciate, CPS has been prevalent for the last 5 years, if not more. The old SASSA card involves a domain of Net1, which is administered by CPS, and what is required is to move on to the new SASSA card, which will have the domain of the Post Office. To return to the observation of the panel of experts, and they said, look, ideally, all the beneficiaries, or recipients rather, must have bank accounts. It would be remiss for me not to point out 2 aspects of that particular scenario.
As you point them out, your 5 minutes is up.
As the court pleases. 2 points I want to make. First is the cost of administering a bank account, which vacillates currently between 7 rands and 55 rands per account. And the second and more fundamental aspect is this. When the money is deposited into the recipient's bank account, control is lost on how the social grantee can control that money because of debit orders. I now want to move on to the cash payment structure, which is the subject matter of this application. Currently, as I've pointed out, 9 provinces schedule payments when the grantee goes to collect the monies.
Mr. Kasim, should you not be focusing on the problematic areas, though?
Chief Justice?
Why did you wait this long before launching the application for,
Yes.
for the extension of the contract?
8th of December, my client appreciates that this is going to be a problem area
Why not earlier?
because it's only on the 8th of December when the contract is finalized with the post office, as the post office says, I don't have the infrastructure to actually do cash payments throughout the 9 provinces. We have 5,000 pay points, but
Yes.
that's not going to suffice.
Was that new information? I thought post office had indicated the last time we were here what capacities they have, what pay points they had, and quite apart from the information they furnished us with, wasn't it incumbent upon SASSA to make its own investigation as to what is it that post office can offer, so that once a view is formed that post office is punching way above its head, then SASSA could look into the possibility of approaching this court when there is still time, rather than behaving as if it really wants to leave this court with no option but to extend.
Chief Justice will recall that in November, the ministerial committee takes over the negotiation of the contract with SAPO. There were problems with the contract with SAPO. Between SASSA and SAPO, there were imponderables where SASSA's view was that SAPO, South African Post Office, did not have capacity to take over this contract. And then comes the ministerial committee at parliament level, supervisory role, and the ministerial committee has, among others, the minister in the presidency at that stage, members of National Treasury, and members of a number of other departmental people. They negotiate the agreement, finalize the agreement on the 8th of December, and on the 8th of December, that particular function is then excluded. So with respect, SASSA appropriately acts from the 8th of December. They start preparing the specs for the new tender. You have your procurement freeze period, middle of December to middle of January. Immediately, the request is issued mid-January. The first closing date is the 2nd of February. That's been extended twice, because on the 28th of January, when you have your compulsory briefing, there are 80 representatives. This is going to be a very sought-after tender, simply because you're administering over 3 billion rands a month. That's the value of this contract. And what happens is, if I may just give you the date, is then extended from the 2nd of February at the request of the people showing interest in the tender to the 28th of February, and finally the closing date is the 12th of March. So with great respect, I would submit that SASSA acted appropriately in the circumstances.
When were the papers filed for the extension?
Sorry?
When were the papers filed for the extension?
The papers were filed, Chief Justice. Give me the date exactly, please.
Okay, to make it easy, was it in January, was it in February?
February, I report.
Why not in January?
Early February, 6th of February.
Yeah, why not in January?
You'll recall that the request goes out for the tender in 15th of January.
And it
Closing date is the 2nd of February.
Yes.
With respect, my clients thought that they could get their act together.
I just wanted to find out whether it could not be anticipated that the tender process was going to take longer, and while that process is lingering on, it might be necessary to approach this court
Well,
when there is still time, so that it's in a position to consider all the available options, if there are more than one option open to it.
Chief Justice, I can't argue the proposition, why wasn't it end of January? I can't argue with that, but it's beginning of February. Yes.
But Mr. Kasim, Has SASSA not been aware since the 18th of December 2017 that it will require CPS cash payment extension?
In fact, they were away on the 8th of December when the agreement is concluded. That's correct. So what happens is we're looking at a tender, and I've said, Justice Kampepe, this is a major tender. I mean, everybody's interested in it because it's over 3 billion rands a month. If you take an economic analysis, and if my clients were being very practical, let's just look at it from this point of view. If my clients were very practical and says, look, we're going to abandon cash pay points, as the expert says, you shouldn't have it unless within the 5-kilometer radius. Where you
I'm sorry, Mr. Kasim,
Yeah.
I apologize for
Yes.
interrupting you. I know your time is limited, but my sister is virtually following up on what I was saying, which is this. And she's very specific. She said, when did you get to know that the extension would be required? You say the 8th of December.
I accept that.
Why didn't you immediately launch the application for the extension then?
Because by that time, what they started to concentrate is going out on tender. So they need the input of National Treasury. They're preparing the specs. It's prepared. The tender is ready to go out. You have a freezing period, mid-December, mid-January. And to come back to this issue of this 2.8 million, the experts point out, they said you don't have to have as many cash pay points. You should only have it outside the region of 5 kilometers. But that's a policy consideration. If one takes an economic analysis, the amount it costs you to actually go to the pay points and to return from the pay point is
You see,
probably...
Mr. Kasim, I apologize again. My
Yes, Chief.
point is simple. When you know as early as the 8th of December that you're going to need an extension, why wait until February before approaching this court? Why didn't you immediately, considering what transpired during the previous court case, why don't you immediately approach the court and say, I see danger coming our way. I don't want to look like I want to bind the court to do, to extend, I beg your pardon, CPS contract. Yeah. When there is still time to reflect on options, I'm launching this application. Why was that not done as early as done while tenders were going out?
Chief Justice, I make 3 submissions. My clients were concentrating on the tender. The second submission I make is that there was the freezing period. And the third submission I make is they genuinely believe that they could get their act together. But I don't quarrel with the argument that as soon as you seek an indulgence from the court, you go to the court the moment you seek it. I don't quarrel with that proposition. I simply point out that in none of the opposing papers is another solution put forward insofar as that real problem exists. Everybody says, we agree you need this service for another 6 months. But nobody says, had you come earlier, you could have avoided it. You can't because you got procurement processes.
No, but it's not known what we would have said had we been approached while there was still time as the court. It's one thing to focus on what your colleagues are saying. It's another to appreciate the need for the court to put questions that could point to another possible solution.
No, Chief Justice, I accept the principle.
Such as the possibility of capacitating post office by pouring resources into it so that it's able to do what is sought to be done by other entities. I'm just thinking aloud. I'm not saying we must address that one. I'm saying it may well be that the court could have put questions that could have led to a realization that the extension of the CPS contract is not necessarily the only solution.
Yeah, Chief Justice will appreciate that the post office challenge, which is really our challenge at this stage from 1st of April, is to convert the old cards to the new cards, bearing in mind the Epe Card, which has been already disseminated by CPS. It's there in the marketplace, it's convenient, but I don't argue with the principle that as soon as we require an indulgence, we should come to court.
Well, Mr. Kasim, I am interested in regard to the earlier period.
Sorry, Justice.
I'm interested in regard to the earlier period as to why SASSA only got to know in December that SAPO can't deal with this part of the matter. If I remember well, when this matter was before us last time, and it may even be the time before that, SAPO was saying they had the capacity to render the service that is required. Now, SAPO is a state entity. SASSA is a state entity. I don't understand why, soon after the matter was here before us, SASSA could not have said to SAPO, in order to be able to do this job, this is what you will need to have. Do you have it? And if they say yes, and they say, satisfy us that you have got it. Was that done? Was that not done?
Justice
Why,
Zondo,
why does it take so many months from the last time the matter was before court, before they know that there is something that SAPO can't do?
And to give a comprehensive answer, also to jointly approach Treasury or government and say, SAPO will need so much money. These are the capacities that would be required for it to be able to execute this mandate. While there is still time, government, please capacitate SAPO, make the resources available so that what it is not able to do as a result of lack of capacity or lack of resources, you can make possible by providing those capacities and resources.
Justice Mokheng, I have some insight into what happened in the negotiations, but let me just say this to you. Firstly, those negotiations was done at ministerial level. And everybody who matters was on that committee. You'll recall that features in the papers. The second is that, of course, there was a solution. There was a solution to buy over the trucks with the software that takes the money to the points. But the question was it possible for SAPA to do so? It was. Was it feasible? It wasn't because of price considerations. You had to buy the infrastructure and the software from CPS, and there was no agreement on that. I don't want to take it further than that, but there was no agreement on that. So that left you in a position on the 8th of December when a decision is taken on economic principles. Look, we rather exclude this portion of the contract, otherwise it makes no economic sense because you're also looking after the money that belongs to the taxpayer. So that then resulted in the 8th of December to say, we will excise this portion of 2.8 million. And of course, from an economic analysis point of view, if Justice Posner now from the United States will be asked the question, he'll say, but it's an easy answer. All you do is you force the recipients to open banking accounts. But that's not the policy that this particular client of this particular organ of state took. They took a policy to facilitate the payment, and they said, which now necessitates us to go out to tender and to bring in somebody who can do this particular service at a reasonable cost. But to achieve that, because you've got to follow procurement process, we then required an extension, and hence we 1st of February in court. That we should have come earlier, I have no doubt, because once you want an indulgence, put your papers into court. I accept that principle. But I'm simply saying that the solution lied in the negotiation process, and it's not to say that this is an imponderable of an achievement, but it was not feasible on economic principles.
Well, I'm not sure that what you have said answers my question. Did SASSA ask at the earliest opportunity after the matter was before us, did it ask SAPO whether SAPO could do the whole job? Did it satisfy itself? Did SAPO say, yes, we can do it? And did SASSA satisfy itself that SAPO could do it? I mean, I think the matter was here early in the year last year, early in the year. And from the papers and from what you are telling us, it seems they discovered in December. I can't understand why it took so many months before they discovered that SAPO could not do this part of the job. So my question is, did they ask them early enough, do you have the capacity to do this job? Did SAPO say, yes, we do? And then later on it transpired they actually couldn't do it. Or did they not ask? Or did they not satisfy themselves?
Justice Zondo, it was always in the contemplation of the parties that this function will be performed by SAPO. It became impractical to do so because of financial considerations.
But
It's not
does that answer say they were asked and they confirmed?
Absolutely.
And they
Absolutely.
confirmed.
It's not that it was beyond the scope of SAPO to do it. It's within their scope, it's within their capacity. It's not a difficult task. It's going out to tender. I've already told you there were 80 people who in the compulsory briefing who wants to tender for this project. But it's a question of, at that particular point in time, acquiring the software of CPS or of Net1. And that became impractical from a cost consideration, and hence the decision on the 8th of December by the Ministerial Committee. Justice Radebe, in fact, signed the agreement by them to say this particular portion will excise from the agreement. And from there, it became SASSA's problem. So it comes back from the Ministerial Committee, comes back to SASSA, and SASSA must now deal with it as the agent.
You see, Mr. Kasim, if one reads the papers here, and in particular I'm referring to the founding affidavit deposed to by Ms. Bengu on behalf of SASSA, one sees what appears to be a pattern where if you look at what steps are taken either by SASSA or the department to deal with issues that need to be dealt with, they seem to be taking their own time. They seem not to deal with matters with the urgency that the matters deserve. I mean, even if you look at its founding affidavit, you look at what steps have been taken and when to deal with issues, you see that there are gaps of 2 months, 3 months, when it appears nothing was happening. You don't get the sense that either SASSA or the department deals with issues properly. And that links up with the point that the Chief Justice was putting to you. You discover in December, early in December, that there is a need for an extension. But nothing happens until February. And in the end, some application is brought here. We don't normally, then we have to try and find time for it within our role. But when you look at it, there was time for things to be done early and to be done properly. But there seems to be an attitude that doesn't seem to care about dealing with issues urgently, that are urgent, and explaining things properly to the court. Yes. It's as if the attitude is the court has no choice, but it will give us what we want. So we don't have to give them a full explanation about what we have done about this. And that attitude is cause for concern.
Justice Zondo, I can assure you the SAPA people, the acting COO is in court. All the senior people are here, and they will obviously take into account.
And it's not a sentiment that is being expressed for the first time by me. It's a sentiment that other members of this court have previously expressed with regard to how either SASSA or the department or both are dealing with issues. I mean, I think the previous extension application that was brought before us also was brought very, very late. So it's cause for serious concern.
A side issue that I need to have cleared in my mind, I concede upfront that it's not central to the determination of the issue, but it's of some importance. So in a nutshell, it would be cheaper for a private company to acquire what the trucks and whatever
Yes.
that are too expensive for post office, a government entity to acquire in order to render the same service.
Yes. It's the infrastructure together with the software package, because you
Yes.
recall the verification, which is a software package.
Even in the long term.
In the long term, yes.
Okay.
Can I make just 2 more submissions? And that is in terms of the SAPO contract, the payment which SASSA will make. SASSA made a payment of 16 rands 44 per transaction to CPS. In terms of the post office contract, it now makes a payment of 6.71 Rand per transaction. There's a saving of 9.73 Rand, so there's a 58 million Rand saving per month going forward in terms of the responsibility which SAPO has now taken over.
Even that won't help SAPO to acquire the infrastructure and the equipment it needs in order to render the service that is to be rendered by outsiders.
You can accept it that the amount that would have required to obtain the logistics and the software package was, for want of a better term, exorbitant in relation to the saving. But why I'm pointing out the saving of 58
Well,
million.
Mr. Kasim,
Yes.
could I ask you, what happens if the court does not grant the extension?
Justice Foreman, sorry, you've got to repeat that.
What happens if the court doesn't grant your application, doesn't grant the extension?
Then we have a situation from 1st of April where some 2.8 million people will be in a position where they go to their scheduled day because payment is made in the first 12 days of a month. So take a place like Kokstad. It's made in a certain area on Monday, Tuesday, Wednesday. People will go there and there won't be monies available.
So you come to us basically giving this court no choice and saying that if the court doesn't make this order, the social grant beneficiaries will suffer. Is that what you're doing?
There will be chaos, they will suffer. Unless, of course, if they get their act together and they open a bank account, then that solves the problem.
But this is a result of the policy decision on your own version not to take other steps.
Yes, yes. I mean, it was a policy decision to excise that particular segment of the services.
So if your policy decision has that effect, isn't the responsibility on your client to ensure, to take other steps to ensure that that debacle that you've put before us does not happen? Don't you have alternative plans?
As things stand at the moment, they don't have an alternative plan. But of course, it lies, the reality is, it doesn't mean to say that the recipient of the benefit is without recourse. It doesn't follow that.
The point is, Mr. Kasim, whose responsibility is it to ensure that the beneficiary receive payments of their grants?
There's no question it's SASSA's responsibility. That's in terms of the law. Can I just make one further point insofar as the other two issues are concerned? Chief Justice, if you want to hear me, the 700 odd There's just two other issues I just briefly want to make submissions. There's some 700 odd profit. You'll recall the debate between the experts whether transfer pricing and tax implications, but ultimately on CPS's version there's a profit just over 700 million. I would submit that it would be a quantum leap in this application if the court was to say that money must go to SASSA. Although SASSA wants the money, I would submit that that particular application is not ripe for hearing. We don't appreciate the course of action. And the other aspect is, insofar as the pricing is concerned, we would submit that CPS is now performing 1/3 of the function. It is the more expensive function because it doesn't rely necessarily on income streams. It actually relies on actual work, and we would submit that that price must be fixed by National Treasury, bearing in mind that we're no longer paying them 16.44 per transaction.
I thought you would avoid arguments that are supposed to be raised by CPS itself.
Yes, but I just want to make those points. Yeah, I mean, because I made those in my submissions, I've got to explain why we thought they should be entitled to a fair and reasonable fee. I understand Mr. Marcus is saying that they should not. It's because we're no more paying them that 16.44 44. So we're saying the services they rendered. It's our responsibility to see they actually rendered the services. It would be foolish for us to expect somebody to take on this particular task under an order of court and not render it properly. We wanted the services to render properly, and they must be compensated for it.
I was just saying it on a lighter note that you wouldn't want to be misunderstood as fighting for CPS.
No, I'm not fighting for CPS, but I must do. If I'm not paying the 16.44 per transaction, which gives me a 58 million rand saving, they're no longer doing 100% function. They're doing, give or take, a 28% function, perhaps a bit less. For that, there must be compensation. The question is, what must they be compensated? We submit, let National Treasury sort that out. That's our submission, consistent with the order. It's in my interest to see that these services are properly rendered for the next 6 months. Those are our submissions.
Mr. Kassam, do you accept then that SASSA failed in its duty to the court?
We've explained the circumstances under
No,
which
I
there was a
understand,
delay.
but my colleagues have put certain questions to you.
Yes.
You've accepted that you could have done it a bit earlier.
Yes.
And given the history of this matter, and I want to put it to you in fairness, because we have to deal with this in a possible judgment. Have you failed in your duty to the court or not?
Justice Kusalia, we're obviously working under trying circumstances. There's 12 billion rand available on a monthly basis. We have all the different forces working against us because it's not an easy matter. As we go out on tender, CPS has the march against anybody else who's going to tender because they've been rendering the services for the last 5 years. These are the realities of what SASSA is faced with at the moment. Now, to say what I can make this submission to you is, and I accept that we could have come earlier, but you bear in mind that there was this interposition, there was this ministerial committee that comes from Parliament that's interposed in the work of SASSA. So SASSA takes a step back. And if all things went right, if the SAPO agreement included this particular feature, then you transferred a substantial responsibility to SAPO, which would have accomplished all the activities, another organ of state, which would have bred new life into SAPO, and I would then have submitted, we wouldn't have found ourselves in this particular position, but it was impracticalities that arose in the negotiation process which resulted in this particular hearing today. And to say, has SASSA failed in its duties? I would make the submission that they've acted to the best of their ability, accepted that they came a week or two late to court in carrying out their obligations.
Mr. Kassam?
Yes.
If I heard you correctly, you said that SASSA was facing various difficulties and all the different forces are working against us. Can you clarify that statement, please? What do you mean?
On a practical level, if you just focus on this particular tender we're going out now, it's not that it's going to be smooth sailing because there's 3 billion rand available. So you have the lobbying group for the banks who want utilization of the banks for this particular transaction. You have SASSA's responsibility to ensure that the entire grant is paid to the ultimate beneficiary, save for...
Sorry to interrupt you. What forces are you referring to that's working against SASSA?
That might have been a wrong word to use, but I'm simply saying there are challenges. There are challenges because when you're administering 12 billion funds on a monthly basis, dealing with the poorest of the poor, you have immense problems because you're trying to protect that money in terms of regulations. 10%, up to 10% can be spent on the funeral policy, not more. Any system you devise, you've got to avoid debit orders. You've got to avoid that amount being reduced by all forms of expenses before the money reaches the hands of the individual person. So
But
I'm simply saying
isn't
there
that
are...
the point exactly? that there are millions of vulnerable people who depend on social grants,
Yes.
and that SASSA should have acted more diligently.
Can't argue with that proposition.
Mr. Kasim, as you sit down, I want to make a comment. It seems SASSA continues to fail to get its affairs in order.
I'm sorry, Justice Kampebe?
I'm saying, before you sit down, I would want to make a comment. It seems that SASSA failed to get its affairs in order. It is a cause for concern that SASSA comes to this court almost like to blackmail this court that if it is not given an extension, then more than 2 million grant beneficiaries will suffer. You have no alternative that you can submit, you will resort to if this court should refuse to grant you an extension. Would that be a fair comment to make?
The facts are put before the court. And we come to the court for an indulgence because the matter is regulated in terms of an order of court. But this is the reality where SASSA finds itself. And as Mr. Justice Forneman said to me, look, if we don't give the order, it's your responsibility, and that is correct. But I said this, and I make this statement guardedly, and I thought it through. It doesn't mean it's the end of the world for the recipients, because it's a three-way arrangement at the moment. There's an arrangement between the administrator, the donor, and the recipient. It's a question of what responsibility one wants to place on the recipient. And in Chapter 4 of the second Auditor General and a panel of experts reports, there's a very useful analysis why more stern steps, if not aggressive steps, must be taken to migrate this 2.8 million people to a structure that's regulated in terms of electronic financing. So when you say to me, Chief Justice, you say to me, is this not putting the court in an awkward position? It is, of course, because the court wants to ensure that this particular agency has a smooth sailing. But I'm saying we had to come to court. If we didn't come to court, we would be criticized. If we come to court, we're putting the burden onto the court. I understand that. But in the end, the challenge is really we're working in the right direction, we're getting our act together, and there's going to be teething problems. Make no mistake, the migration of 6 people from one card to another card is going to be enormous problems, because we can't, nobody here can understand what the mind of the old card holder, the state of mind of the old card holder holding that card. I can't force people to come and exchange it. And if they come, it's a 10 minutes process. But what do? I've advertised, I've told people, but short of not paying them, which is probably the greatest incentive when they'll come and change their card, but short of not doing that, I'm really in the hands of unpredictability. That I can take steps to bring them to the party, of course, education, send my people out, but ultimately, I can't bring a recipient or a beneficiary by force and say, come and change your card.
You know,
That
Mr.
in itself is going to
Kasim,
be a problem.
What my sister and all of us are shocked by is this.
Yes.
About 2014, all pay was decided, saying this is an unlawful contract.
Yes.
Up until now, I think it's a full presidential term of an American president. Nothing has been achieved. The court is still being approached after so many years of saying this is unlawful. And unlawfulness continues to be perpetuated while we are watching. It's very sad
Justice Mogoeng, a lot
for
have been
anybody charged with this sensitive and enormous responsibility. It's like we are being laughed at by SASSA and CPS. It's most unfortunate. And what is even said is that there is no explanation. You know, when somebody has done wrong and they have an explanation to provide that we can all relate to, it makes a lot of difference. No explanation. that we can understand has been put before us. It's sad. He just wanted to make that point. I don't think my sister was asking for a comment. I'm not asking for a comment.
I understand
We're just
that.
expressing our frustration to your client. Most unfortunate. You assume a responsibility or you reject it on the basis that you don't have what it takes to discharge it. Simple. Anyway, thank you, Mr. Kasim.
Thank you, Chief Justice.
Mr. Kasim, just one thing to clarify.
Yes, Justice.
Is there any particular reason why the relief sought by SASSA was limited to the cash payment extension and not including the phasing in and phasing out that you have made submissions on now?
Sorry, Chief Justice, I understand it. Why is the application limited to that?
The reason that we were given by SASSA for the extension
Yes.
was that SAPO does not have capacity to pay or effect cash payments. SASSA did not tell us that it would require extension as well for the phasing in and phasing out portion of the program so that SAPO can effectively take over.
Justice Jafta, that is really SAPO's responsibility now. We have a contract with SAPO, 1st of April, that's their responsibility. So we one step removed. But I had to point that out to the court because this is practicalities when you migrate from one system to another system. So from SASSA's point of view, we have a contract with SAPO. The one aspect that's excluded is why we are here. The rest is their responsibility from the 1st of April.
But did SAPO say, when the contract was concluded on the 8th of December, did SAPO say it would be in a position to take over the rest of the grants payment, excluding only the cash payments as from the 1st of April?
That is contractually their responsibility. And remember, the advantage with the SAPO contract is that when the money is put into the SAPA account, when it administers it, there's only one deduction permissible, which is your Regulation 28, which is your funeral policy up to 10%. No other deductions. So that's really the differentiating point between the SAPA contract with the SAPO using its bankers, then money paid directly into other bank accounts. But that is SAPO's responsibility from the 1st of April. But on a practical level, your phasing in, your phasing out will not deter SAPO from carrying on its responsibility, provided the recipient changes the card. That's the only point I made. I said there is going to be teething problems.
Thank you, Mr. Kasim.
Thank you, Chief Justice.
Mr. Badlander, are you first or is it Mr. Marcus first or does it not matter?
Chief Justice, I'm older than him and I'm higher on the list. He admits the first.
Very well.
Chief Justice and members of the court, today we find ourselves here again for the second time in 12 months in an urgent application. It's an urgent application which arises from the failure of the minister and the failure of SASSA to carry out their constitutional duties. It's another last-ditch attempt to avoid a disaster. It is with respect shamefully late, and yet again, for the second time, puts the court in a position where it is faced with a fait accompli. I need to say something about the role of the court in this thankfully unusual situation. These, I submit, are not ordinary adversarial proceedings. They are closely linked to, and in fact part of, the court's exercise of its supervisory jurisdiction when it saw the difficulty. It is part of the court's attempt to ensure that 17 million vulnerable beneficiaries are not harmed as a result of incompetence and negligence on the part of those who owe them a constitutional duty, in the first instance the minister and the SASSA. And so the court has already necessarily undertaken a more active role in exercising its supervisory jurisdiction than it would do in cases which come before it. It has appointed an expert panel to investigate and make recommendations. That has been the one ray of light in the Surrey saga. And I pause to note, in relation to what my learned friend just said about how SASSA has not dragged its feet. The panel itself says that SASSA has not produced information when requested, has not attended meetings when requested, has dragged its feet, and has obstructed the process of the panel, let alone the process of this court. The core goal of the exercise, I submit, is to ensure that the constitutional and statutory right of the beneficiaries to social assistance, the constitutional right under Section 27, the statutory right under the Social Assistance Act, that it is fulfilled in full measure. That requires protection of the beneficiaries, and that is the part which is the concern of the Black Sash. I want to turn immediately to what is the main risk of harm, the core risk of harm to the beneficiaries for which we submit protection is needed. And it all arises from these dual contracts, the contract with Grindrod Bank for what is called a SASSA branded card, and the contract with CPS for what is called the Epe account. CPS says that these accounts are just bank accounts, like other bank accounts. They can be operated just like other bank accounts. It's simply a matter of a contract between a bank and its customer, and no one should interfere with that. That's what's being argued in the matter which is currently pending before the Supreme Court of Appeal, the Net1 case. It's not just an ordinary contract. One needs to look at how the cards and the contracts actually work in practice. We know that contracts are supposed to be consensual, that's the essence of a contract. So how do the cards work? What happens is that when you register for a social grant, you provide CPS on behalf of SASSA with all of your relevant personal information. That is loaded on a SASSA branded card with Grindrod Bank. It's an account held at Grindrod Bank, and it bears the SASSA imprint. It enables you to get access to your money when it's paid into that account at ATMs, through point-of-sale devices, and at certain merchants. But then there's a second card. The second card is the Epe card. It is a product of Moneyline, and Moneyline is one of the other subsidiaries of Net1. CPS is a subsidiary of Net1. Moneyline is a subsidiary of Net1. They're sister or brother companies. And the way the second, when you register, when you get the second card, your personal information is transferred from your SASSA card to your Epe card by the simple device of putting your finger on a sensor. And all of the information then shifts across. But the result is that the members of the Net1 group have access to your personal information because they have access to the key which operates the EZE, the Epe account. That is explained by Ms. Mart, Volume 3, page A224, paragraphs 25 and 26, and has not been placed in dispute by CPS. Now, CPS says all of this is contractual. This is just another bank account. CPS says that the grant beneficiaries consent to the terms of these contracts, the Grindrod contract and the Epe contract. The Black Sash's attorneys wrote to CPS and asked for information on the means through which beneficiaries are informed of the terms and conditions of these two accounts, which they sign on to by putting their finger on a censor? And the answer you will find in volume 3, page A241. It's paragraph 3 at page A241. A243, I beg your pardon, is the answer, paragraph 4. And this is what it says. This is now CPS lawyers answering how people are informed. The terms and conditions are currently only available in English and displayed at all enrollment stations. So you see them by seeing them on the wall in English. Continue, quote, as part of the process, the beneficiary is prompted to place his or her finger on a scanner to biometrically verify that he or she has received, read, understands, and accepts the terms and conditions. The words, quote, I biometrically verify that I have received, read, understood, and accept the terms and conditions, close quote, appears on the screen. The process cannot continue until the beneficiary acknowledges same biometrically. And one asks the obvious question, what on earth does one expect that the beneficiaries are going to understand by all of this? The contracts you will find at volume 3, page A246 to 247. That's the EPE contract. And volume 3, page A248 to 250, the Grindrod contract. They are, for practical purposes, identical. I want to draw the court's attention to two provisions of this contract to which people agree by putting their finger on a sensor. And I'll use the EPE contract at page A247. First, paragraph 15.1. This is what people agree to by putting their fingers on a contract which they could never have read. If there is a difference between your records and ours, our records will be regarded as being correct, unless you are able to prove otherwise. So millions of people agree to this by putting their finger on a sensor, and they agree consensually, we're told. Secondly, paragraph 15.3, clause 15.3, quote, we may amend these terms and conditions at any time. Publication of such amendments, by such means as we may select, will constitute valid notice of the amendment to you, and such amendments will be immediate effectively. What sort of contract is this, or what sort of consensual contract is this? This is a contract in respect of which huge numbers of people have put their fingers on a sensor. CPS says this is all consensual. We say not. The number of people taking up the EPE card, has rocketed. I'll give the court the references. In February 20th, it's the affidavit of Ms. Mart, it's volume 3, page A230 to page A231, paragraphs 40 to 42. In October 2015, there were 350,000 EPE accounts which had been opened. In December 2015, 2 months later, it had almost doubled, 600,000. April 2016, 4 months later, 1,087,000. August 2016, 1,430,000. And last month, in February 2018, 2.3 million. The overwhelming majority are social grant beneficiaries. And Ms. Mart explains why this has been done, and I do want to read this to the court. It's volume 3, page 229. And this also is not disputed. Volume 3, page A229, paragraph 39. Net1 in its media communication, now Net1 is the parent company of CPS, Moneyline, and all the rest. Net1 in its media communication, which is attached, was explicit that it will not submit a bid application as engagement with the government. This was at the time that the government was putting out bids after the 2014 decision of this court. It was explicit that it will not submit a bid application as engagement with government, particularly SASSA, is too onerous and risky. It stated that it would continue, quote, providing a comprehensive suite of transactional products and services which will allow it to service all South Africa's unbanked and underbanked citizens, including social grant beneficiaries, but independently and without SASSA's limitations and constraint. The company's business plan includes the continued successful deployment of its Easy Pay Everywhere bank account. The company believes that these activities, now these are the EPE activities, will ensure a sustainable business model that will, over time, far exceed the benefits that could be realized from being the successful bidder for the SASSA RFP. In addition, the execution of the business plan will no longer be limited by a 5-year contract, or potentially shorter if legally challenged, and provides the company with the ability to freely determine pricing that is both competitive and profitable and removes any unknown or contingent liabilities associated with government contracts. So they decided to move out of contracting with government because it was more profitable to set up the EPE cards outside government, because that much more profit could be made that way, and I'll show the court that that is what has in fact happened.
Mr. Matlenda, your 10 minutes is off, but I just want to appeal for help from you and obviously from your colleagues as well. As I understand it, there are basically 3 issues that we called upon to decide, apart from costs. The first issue is whether or not the protection of the beneficiaries that flows from the Black Sash judgment is adequate, or whether there are deficiencies which justifies rephrasing that order so that it provides adequate protection to the beneficiaries. And the second issue is whether or not this is the right forum, the right platform from which to be asking that an order be made for 700 million rands ought to be paid by CPS back to the state, obviously SASSA. And finally, whether it is appropriate to make the order proposed by CPS that it be authorized by this court to submit such amount as it considers to be a fair reflection of the cost it has incurred to Treasury, and for Treasury to express agreement or disagreement within 30 days of the submission of the amount. I'm paraphrasing. But basically, as I understand it, those are the problem areas. And we would benefit immensely if the submissions by council would be focused on helping us to determine those issues.
Thank you, Chief Justice. I'm addressing the first issue, the problem of protection of beneficiaries, and I'm going to make the submission that the mechanism from which the beneficiaries need protection are the EPE cards, and I'll make a submission as to how that protection can be achieved.
Yes.
So I'm building to that submission.
Is it possible, just in the interest of time, to focus on what needs to be done so that Mr. Kasim and others and Mr. Morrison know exactly
Yes.
what needs to be done to accommodate your concerns and those of Mr. Marcus adequately?
I will attempt to do so, Chief Justice. So, to cut to the chase, as it were, what happened, Dr. Forsland shows, and I'll just give the court the reference, that from 2014, as the uptake of EPE cards increased, the CPS contribution to Net One's profits proportionately decreased. It started at around 40%, now it's in the low 20s. In other words, the profit coming to Net One is now coming not mainly from CPS anymore, it's coming from the other subsidiaries, and we suggest as a result of the EPE card. Dr. Forsland makes that point. It's volume 3, page A276.
Volume?
Volume 3, page A276 to page A278, paragraphs 44 to 49. What has happened is that the EPE cards allowed the other subsidiaries to get access to the beneficiaries and their information, and so their profits have gone up. CPS has proportionately come down. It's dealt with again by Dr. Forsland in volume 3, page A275, paragraphs 40 to 41, where he makes the point, if I can just read one paragraph. They say, this is what CPS says, or rather what Net1 says, the parent. We created the automatic debit feature to allow a smart card to reduce the balance in any of its active wallets on a specific date and for a predetermined amount. This function can take place in an offline environment at any POS device. The automatic debit feature reduces the risks associated with collection of insurance premiums and other regularly scheduled amounts. Well, it doesn't reduce the risk. It means that there's no risk because you've got the guarantee because the money's there. It does this, it says, by ensuring that any funds loaded to the smart card are first used to service the automatic debit before being transferred for the cardholder's general use. So that's the mechanism. It's explained also by Ms. Mart, volume 3, page A223, paragraphs 24.2 to 25. She says that the loading of the beneficiaries' information gives access to this information to all the entities in the Net1 group, and that's not denied. But people do sign, they sign in increasing numbers, from 350,000 to 2 million. And one can only guess how many more there will be if the CPS contract is now extended for a further 6 months. The point made by Net1 in the passage that I read is that these aren't customers for the duration of the contract. They're permanent customers because they're now on your books. You've got all their information, you've got access to it. It's the gift that keeps on giving. Even when CPS exits, if it does in 6 months' time, you've still got the 2 million people on your books. So why do people sign on? CPS says because the product is marvelous. Beneficiaries say, or some of the beneficiaries say, that officials tell them that the green card is the new SASSA card. Some of the officials, they say that they've been told that you have to have the green card to get your grant.
Mr. Bartlander, I'm sorry. How can the deficiency be cured? How should we structure the order in order to provide beneficiaries with optimum protection? We appreciate there are problems, but can you cut to the chase, as
Chief
you
Justice,
said?
I'm sorry, Chief Justice. The answer, Chief Justice, lies in the regulations which the Minister made, which are in volume 9, page C85. And what those regulations say, it's regulation 21.1, if I can just get it. It says the agency shall pay a grant A into a bank account of the beneficiary or institution where the beneficiary resides, provided that the beneficiary of the social grant consents to payment in accordance with 21.1A in writing and has submitted such consent in person to the agency. So you can sign on to a bank account and then it's paid into the bank account, but you must sign on and you must present that to SASSA. Now, that doesn't happen when a beneficiary puts his or her finger on the sensor, with the result that the grant money is transferred into the EZE account, Epe account. And so the expert panel has recommended to the court that this be regularized, and has recommended, I'll give the reference, it's the third report, volume 8, page B326, paragraph 6.6, and it's dealt with further in volume 8, page B296, paragraphs 3.1.9 to 3.1.11. What the expert panel recommends is that this be regularized by people being required to give written mandates to SASSA, saying that they want to transact through a bank. It's also what SASSA says it wants to do and has started doing, and they will find that in volume 12, page C372, para 3.3.2c. And so that, Chief Justice, is the solution to the problem of EPE accounts. The beneficiaries who want it must sign up for it, as the regulations require. That's what the panel recommended, and that's what we ask the court to order. In our affidavit, we suggested a moratorium on the issuing of new EPE cards. On reflection, that may be less effective than something which regularizes all the EPE cards and makes them subject to the regulations. There are two qualifications which are needed and which I need to explain to the court.
And before you come with the qualifications, before the thought escaped my mind, would you and Mr. Morrison and Mr. Kasim, during the break which will follow at the end of your submissions, see if that's something that you can agree to, whether that rephrased order in order to provide optimum protection can be agreed to by the
We'll be
parties.
delighted, Chief Justice.
Yes.
So the two qualifications are the following. Firstly, where there's an existing EPE card, you can't simply stop paying into the card because the beneficiary will arrive at the end of the month not knowing anything about it, put the card into the machine, and no money will come out. And so what we submit is that the order should be, what the court should direct, and I'll raise it with the learned friends, that there may be no deductions or debit orders from the EPE card other than cash withdrawals, unless the SASSA has been given a written mandate by the beneficiary to pay to the bank. What that will mean is that the grant will continue to come in until it's all put on a proper footing. People will get access to the money, but that will be the end of the matter. And that, of course, will be a temporary arrangement because in due course, so we believe, everyone will receive a SAPO card into which the grant will be paid, and the EPE cards will then not receive the grant payments. The second qualification is that the order of the court will need to be explicit in this regard, and I need to explain to the court what the difficulty is. The regulations deal with the account into which CPS on behalf of SASSA makes payment. And if it's a bank account, there must be a written mandate. Now, there's some dispute as to what happens when you've got an EPE card. Does the money come into the Grindrod account and then go out to the EPE account, or does it go directly to the EPE account? And there's a dispute about what the mechanism is. And we say that either way, both of those must be covered. It's paid directly by CPS, the paymaster, and it should apply whether it's paid directly into the EPE account or via a Grindrod account.
Just to make sure I understand the first point, does it relate to all deductions, irrespective of who the money gets paid to, who the deduction goes to?
Yes, Chief Justice.
What if it's a genuine transaction between the recipient and an insurance company, and people just want to be insured in case they die?
Because, Chief Justice,
Is it not going to result in an unfortunate and unintended termination of an otherwise valid and legitimate insurance, what do you call it, policy?
Well, it would be possible for the court to carve out a separate dispensation for Net 1 subsidiaries and say this applies only to Net 1 subsidiaries because they are the sisters and the brothers of CPS and they can deal with the situation, and others shouldn't be affected. But that's a more limited form of order. In principle, it should, we submit, be the default position that without a mandate, you don't get payment. But I understand the point that the Chief Justice is raising. We submit that if this mechanism, which is the mechanism recommended by the expert panel, that now all of this must be validated through a mandate, a written mandate, if that's implemented, grant beneficiaries will be substantially protected against exploitation or overreaching. It will not be perfect protection, but at least we will know whether the 2 million EPE holders really want an EPE card and all that goes with it, because they'll have to sign on properly. And they'll have to sign on under supervision of SASSA, which will presumably explain to them what they're signing on to. Moneyline will then have to do what any commercial bank has to do, sign up the client with a proper written mandate. It will level the playing fields. All the banks have to sign up on the same basis with a written mandate. And we say just applying the rules to the EPE cards will provide substantial protection to grant beneficiaries, and the court, the submission is that the court should therefore order that Regulation 21A1 will apply to the EZE accounts whether the money came in directly from CPS or whether it came in from CPS via a Grindrod transfer. Chief Justice, those are the main submissions I want to make. The two other matters I'd like to deal with briefly, if I may. There are two other problems which need to be addressed as far as protection is concerned. The first is the recourse and grievance mechanism for people who have difficulty with the system. I'm not going to go into that. It's dealt with in the papers. The expert panel has found that the current system is, quote, wholly inadequate, close quote. And you'll find that at volume 8, page B285, paragraph 1.2.1, and it's further discussed in volume 8, page B, 297 to 300. CPS says there are no problems, it all works terrifically. This is, of course, a systemic issue, and it's quite a simple thing to test. All you've got to do is send somebody to one of the pay points, send somebody with a problem, let them try to phone CPS, let them try to phone Moneyline or whoever. It's a very simple thing to test. And we ask that the court request the expert panel to investigate the matter as to how the recourse mechanism works from the beneficiary's point of view, and to make recommendations as to how it should be improved if it considers that necessary. This Chief Justice is likely to be an ongoing issue. It's not just a matter for the next 6 months. It's a permanent issue which needs to be now properly put to bed. It has never been put to bed. The second
Is SASSA keen to address it? Because we may be burdening them with something that as SASSA is willing and able to do.
Well, the first thing, Chief Justice, with respect, would be to find out how does the system work and what are the defects in it, if any. And if proposals are made, no doubt the court would want to hear from SASSA, from CPS, anyone else before any order was made. This is really a fact-finding exercise and getting a recommendation from experts. The second issue is as I said to Chief Justice earlier this morning, I said I wanted to say something for 2 minutes about the question of profits. I'm not going to enter upon the debate about whether there should be profits, if so, what sort of profits, should there be pay back the money, any of that. I'm just wanted to say 2 minutes about what is a profit. The fact, as one knows, and as Dr. Forsland has shown, is that CPS now contributes about 20% of the profits of Net 1. The bulk comes from 2 sources. It comes from what CPS pays to Net 1, its parent company, licensing fees, fees for services. Those are the things which are always vulnerable to transfer pricing. And secondly, it comes from the profits made by the other Net 1 subsidiaries, Moneyline, Manje Mobile, and SmartLife. SmartLife provides funeral benefits. We were told in the Pretoria High Court that it's only funeral benefits for grant beneficiaries. It seems to be a profitable business. Those subsidiaries would not receive these benefits if it was not for the unlawful contract. If it weren't for the unlawful contract, there wouldn't be the Epe Cards, and they wouldn't have access to this information and access to the beneficiaries. They've built their business on the back of the unlawful contract, which has been continued in operation out of necessity. And so we say that perpetuating the unlawful contract necessarily perpetuates the situation that the other subsidiaries will make their profit, and it will of course continue even if the new contract is not extended, but I'll leave that for the moment. So in all pay 2, this court required a full disclosure of CPS's income, expenses, and profits under the invalid unlawful contract. We submit that the same should apply on whatever order is made in that regard to the profits of CPS's fellow subsidiaries. They only made the profits because they are fellow subsidiaries and the CPS unlawful contract has been extended. And that's just an accident of company structure. If all of the work was done by CPS, then all of the profit would find its way into CPS. Instead of doing that, the work is done by 4 different companies. It finds that the profit finds its way into 4 different companies, all of it into the hands of Net 1, the holding company. And so we submit with respect that any accounting for and investigation of profits must include the profits of the other Net 1 companies which transact with beneficiaries and derive profits from those. Those, Chief Justice, are our submissions.
Just one question, Mr. Butlander. None of those entities are before us.
No, but the court can order an investigation into what's going on without making any order against them. The court can say, when you find out the profits, find out what the profits are of the other companies, and obviously all of this will have to come before court for a decision, this court or another court for a decision as to what, should there be a disgorging of the profits, what are the profits. Those parties can then be party to the exercise. This is just a fact-gathering exercise.
Advocate Butlander, do you accept that in the event of the extension of the contract, that the amount of 1644 per beneficiary will substantially increase in respect of the cash services to be provided by CPS as suggested by CPS?
Yes, I can't, we don't have the facts as to the numbers, but it's logical that that the most expensive part of the service is putting cash in a security van, taking it out to the people and having security people and others there. That must be the most expensive part of the service. You would expect that that's the most expensive, and the least expensive is what SAPO are generously doing for R6 something. That's actually the easiest and the least expensive part, what they're doing. Thank you, Chief Justice.
Thank you, Mr. Butlander. The court will adjourn for about 15 minutes.
Do you like it here?
Why don't you give us a draft of your precise prayer?
I'll ask somebody who can write it.
All right.
Sorry.
Is this Jeff's? It's going to take my 40 minutes. Why is complaining? Yeah. 30 minutes.
Yes, Mr. Marcus.
Thank you, Chief Justice. Chief Justice, mindful of the discussion that has already taken place, we propose to address two issues, and they are in fact the remaining three issues which you identified. So firstly, we will deal with CPS's arguments as to why they say they should not be required to pay back anything, and why they should be permitted to negotiate with Treasury for what they call a fair and reasonable fee. And secondly, and briefly, Chief Justice, we will deal with the question of costs. By way of introduction, we are, of course, like everybody else here, simply unable to properly resist the core relief sought by SASSA for the extension of the contract. In truth, we, like everybody else, are left with no option because the court is once again faced with the spectre of chaos. Let me, before addressing the contentious issues of repayment, dispose of one issue which concerned the possible transfer of the administration of the SASSA Act and the Social Assistance Act as recommended by the expert panel. At the time that our affidavit was deposed to, which was the 14th of February, there was uncertainty as to who would be the president, and we now know that there is not only a new president, but a new Minister of Social Development who has filed an affidavit, so we cannot and do not persist in any relief relating to the transfer of the administration of those two statutes. CPS argues, Chief Justice, that it is under no obligation to repay its admitted profits after tax of some 700 million rand. In fact, it contends that it is entitled to not only retain all admitted profits historically, but to make a profit going forward. They raise four arguments, and I will identify them and then address each of them in turn. Their first argument is that because this court suspended the invalidity of the contract, this, they say, rendered the contract valid for its duration. Hence, they say they are entitled to derive profits from the validated contract. That's their first argument. Their second argument is that this court's orders, not only in All Pay 2, but in fact in two other judgments, required nothing more than public disclosure of their profits, and that it was a mere public accounting and nothing else. Thirdly, they contend that repayment would not be just and equitable. And lastly, they say that this is not a matter to be decided by this court, but rather by the High Court and the Supreme Court of Appeal. By way of introduction to answering their first argument, can I just make clear what I mean by way of terminology? I will refer to the no profit principle. In truth, we know it is what this court described as the equilibrium, which strikes a balance between not making a profit on the one hand and not being compelled to bear a loss on the other. I will simply refer to it as the no profit principle by way of shorthand. Importantly, Chief Justice, this court has laid down that principle 3 times. It did so in All Pay 2 for the first time. It then did so again, and in important terms, in All Pay 3, which seems to have fallen completely off the radar of CPS, and it is in fact reported, if I could give you the All Pay 3 reported reference, it's 2015, volume 6 of the Butterworth's Constitutional Law Reports at page 653, and it did so a third time in Black Sash 1. It is not necessary for me to reiterate a principle articulated on no less than 3 occasions by this court. I do wish to make 2 points before addressing CPS's first argument. The first is this, is that in Allpay, this court chose to establish and retain a supervisory jurisdiction. Pursuant to that jurisdiction, this court articulated the no-profit principle and imposed a range of reporting obligations, and it did so in the absence of any request by any of the parties to that litigation. So it was something which this court did pursuant to its supervisory jurisdiction. The second point I want to make is this, is that the no-profit principle having been established in Allpay 2, it was reiterated in Allpay 3, and its obligations from judgment can only be specified by itself. Are really the product of the fact that this court found the contract to be unlawful, and moreover found that CPS occupies the position of an organ of state. With that introduction, let me deal with CPS's first argument, and it can be disposed of very quickly. They say, well, ended the order of invalidity, that thereby validated the contract. Under the so-called validated contract, they can derive a profit. But that argument, with respect, is already foreclosed conclusively by Allpay 3 and Black Sash 1. In Allpay 3, this court was explicit. It said that notwithstanding the suspension of invalidity, CPS was not entitled to benefit under the contract. This is what it said in paragraph 15 of Allpay 3. It should not be, I quote, it should not be forgotten that our judgment in Allpay 2 clearly stated that despite the suspension of the declaration of invalidity of the contract, CPS 1 has the constitutional obligation to ensure that a workable payment system remains in place until a new one is operational, and 2 has no right to benefit from an unlawful contract, and 3 was ordered to account for its benefits under the invalidated contract. So on that score, the answer is clear. There is no room for the argument, and for the sake of completeness, the same point was made in Black Sash 1 at paragraph 40. I don't need to read what was said there. CPS's second argument is this. They say, we all misunderstand Allpay 2, Allpay 3, and Black Sash because what was intended was a public accounting and nothing more. We submit that that argument is unsustainable for 4 reasons. The first is that it would reduce this court's orders to a purely academic exercise. Nothing would flow from the no-profit principle itself, nor its obligation to make disclosure of its profits. And we would submit that CPS's argument is simply implausible. We go further. This court did not simply require CPS to provide an audited statement of its profits. It went further. It additionally required that those statements be independently verified. That dual purpose, we submit, was obviously intended to give effect to the no-profit principle and required repayment. The second reason why this argument we submit is bad is because CPS misunderstands why this court did not actually immediately order the repayment of the profits in Allpay 2 or Allpay 3, or indeed in Black Sash. This was because, as the court will recall, CPS had claimed that it might make a loss if the contract ended early, pursuant to a new tender being awarded to another party. So, faced with the suggestion by CPS that it may make a loss if the contract ended prematurely, this court was explicit in paragraph 67 of All Pay 2, where they said the solution to this potential difficulty is relatively simple and lies in Cash Paymaster's hands. It can provide the financial information to show when the break-even point is arrived or will arrive, and at which point it started making a profit in terms of the unlawful contract.
And the 10 minutes is up.
Thank you, Chief
I'm
Justice.
just trying to remind myself, what is it we had in mind when we made that statement?
Yes.
and focusing more on the practicalities and why a company in the position of CPS wouldn't find a reason just to fold up instead of reporting for work and getting nothing out of it. I'm just trying. Was it not meant to convey this message? As I said, I don't remember exactly what we had in mind. Don't try to exploit the system. You are unlawful. We have so declared. Don't try to get more than you are entitled to get in terms of that unlawful contract that you had entered into. Does it mean now you must just come to work? As long as petrol and other things are paid for, you can't get any additional benefit. Is that what it means? I'm just trying to grasp the fundamentals of the principles you're articulating.
Yes.
What was sought to be conveyed there?
Chief Justice,
and the context
Chief
at
Justice,
the time.
I accept your invitation to interrogate the fundamentals of the principle, because that is terribly important. And perhaps the most important reason underlying that principle is that it constitutes a very important safeguard against abuse or corruption in tender processes. In other words, it signals to those who may be tempted to take shortcuts, and at this stage I'm not saying whether those shortcuts are procedural shortcuts or shortcuts by way of corruption. I'm just using the word generically. It signals to those who are tempted to take shortcuts that our courts will not permit a party to derive a profit when this occurs. So it creates, in our submission, a powerful disincentive to abuse of any sort, whether deliberate, corrupt, or otherwise, or conversely, it creates an incentive on bidders and those granting bids to ensure that everything is done lawfully and procedurally fairly.
Allow me to interrupt you so that I understand. Was this not the position? Was CPS not trying to sort of renegotiate what it had originally agreed to? And does that not inform why we even wanted to know how much it has harvested over the years, so as to counter the argument that I think was advanced to the effect that no, we're barely surviving, we're not making profit. To say, look into these people's books. They claim to be barely surviving. Let us see the profit margin, whether there is any justification whatsoever for an increased payment, or whether what was originally agreed to would see them through, considering that the contract is unlawful.
Yes.
I don't know if what was sought to be communicated by that statement was, all right, if it were a legitimate or a lawful contract, they would have been entitled to profit. Now that we have declared it unlawful, anything that represents profit must be removed.
Yes.
In other words, we are now going to have to scale down the fee that, 16 rand something, that's 16 rand something, and whatever else they were in terms of the extended contract entitled to charge.
Yes.
I don't know. Maybe you are right, but I just wanted to have the benefit of your argument while you're still here. I don't know if you're not overstating the principle.
2 points, Chief Justice. The first goes, of course, to the underlying principle, which is a principle of unjustified enrichment. That principle, of course, takes as its point of departure that no one may profit from an unlawful contract. It is true that the courts, in certain circumstances, have the power to ameliorate those consequences. In this particular case, again, going back to the genesis of the rule, Chief Justice, you will recall that this court was faced with an ultimatum. There was I perhaps should put it gently, there was a suggestion, perhaps more than a suggestion, that if the court invalidated the contract, CPS would simply walk away. It was in that context that, first of all, the no-profit principle was articulated, and secondly, CPS was held to have the obligations of an organ of state for that purpose. When the matter was argued in Black Sash 1...
Before you go to Black Sash, that organ of state principle, was it not intended to say, you are bound? You can't just dump the beneficiaries of the grants like that. For you are in this contract, you've benefited unlawfully, until such time as a suitable replacement is found, you are bound to assist the South African public.
Yes.
And added to that also, as my rusty recollection of this principle is that don't come to us and be claiming more than you have been receiving. You can't go beyond the 16 rand, something on the basis of the, what do you, I'm not the man of money now, what do you call these things? Inflation and whatever else. You stay within the original parameters, considering that you are illegitimate, for want of a better expression.
Yes. Chief Justice, all of those considerations undoubtedly underpinned the court's reasoning. And I don't take issue with any of that at all. The only further point I would make is that the issue was fleshed out, for want of a better description, in Black Sash. Because it was in Black Sash that the court spoke of the equilibrium. And the equilibrium was the balance, on the one hand, between not profiting, and on the other hand, not being out of pocket. For want of a better description, what the court envisaged in our submission was that where a contract is declared to be unlawful, while we will not require you to carry on at a loss, we will not permit you to make a profit, we will accept the break-even point. And that is why we are telling you, come and tell us at what point you make a profit and how much it is, but we're not going to take you at your word. We want an independent verification. Now, that process has half taken place. CPS has filed its audited statement of 700 million rand after-tax profit. That is what we say is now repayable. And really the most powerful underpinning of it is the one that I mentioned a moment ago, is that it is a terribly important safeguard against abuse, and I use that term to cover both procedural irregularities as well as worse, like corruption.
And on the assumption that you are correct, you say it's open to us to make an order for the payment of that money right now.
2 points, Chief Justice. On the 700 million, there is no dispute. This is what CPS has come and already told the court are its admitted profits. It is possible, and we make provision for this. I'm going to talk to you at the end of my address about a proposed order. It is possible, of course, that the independent audit will reveal that CPS has understated its profits. And that's the precise purpose served by the independent audit. But when that happens, then if the court accepts the independent auditor's report, then all that will happen is that CPS will be ordered to pay over and above the 700 which they have admitted.
We deal with it piecemeal?
Well, what is critically important, and it relates to the capacity of CPS to enter into negotiations with Treasury. We respectfully submit that it is now imperative for the court at least to make it clear, if it is not clear, and it's certainly not clear to CPS, that what the no-profit principle means is that once there are these audited statements, and once they have been verified, it means payback. It means pay back the money. That's what it means. CPS takes a fundamentally different view. They say they don't have to repay back anything, and importantly, going forward, for the very purpose of this extension, they seek permission from this court to negotiate with Treasury, not for a break-even number, but for what they call a fair and reasonable amount. So I accept, Chief Justice, that the court might think it's appropriate to await for the independent audit to come in, but what we do submit is that it is now fundamental for the court to say that this either was an academic exercise or it means pay back the money at the appropriate time.
You know, you may be right about your interpretation. As I said, I don't have a clear recollection of what exactly we meant by that statement, but here is my fear, because it's always important to reflect on the implications of whatever position you take as a court. Here is my fear. Another company may well find itself in the position where CPS is, where a critical service must continue to be provided to the public. And I don't know if it is very difficult to justify winding up. Boom, gone. And the public is left without any. We must appreciate the risks of what we are doing. Is this practicable? Is it a theoretical possibility or also a practical possibility? I'm just worried. That's the worry that comes from my gut. Is it realistic? I don't know. But proceed with your argument. I just wanted to mention that also for the benefit of my colleagues who might be remembering better and are able to allay my fears through the questions that they put to you.
2 points, Chief Justice. I accept that one must be cautious. When I say one, I accept the court must be cautious of not necessarily laying down a one-size-fits-all. But in this particular case, in relation to this very contract, this court has laid down the principle 3 times. And it is now of critical importance for in fact, CPS going forward, because they actually need to know what the parameters are of what the negotiations will be to fix a price for the next 6 months. So even if the court takes the view that this is not the occasion to say, right, we now have the complete independent audit, you have to pay back. What we would, with respect, submit is appropriate is for the court to say that when that happens, it will mean that the money does have to be paid back and that this is not simply an academic exercise of accounting in the air.
See, Mr. Marcus, the difficulty, and I've looked at the judgments. I mean, initially, there was no explicit finding of wrongdoing against CPS. CPS is then visited with the constitutional obligation pursuant to an invalid contract. Through no fault of its own, the 6 months has to be extended, further 6 months has to be extended, a further 6 months has to be extended. And on each occasion, it is told not only that you cannot profit, but you cannot even you can't even charge a reasonable fee. And if that is the implication, and at first blush it may well be, what the judgments appear to say, it would indeed be quite extraordinary.
Justice Kachalia, yes. 2 points. I have sought to stress what we submit is the critical policy consideration underlying the principle as a safeguard against abuse. It is true that CPS was not found to have done anything corrupt or dishonest in that sense, but it is equally true that one of the 2 bases upon which the contract was set aside was that CPS's BEE partners, who were going to be responsible for some 70% of the contract, were not subjected to critical scrutiny in any way whatsoever. And for that, CPS has to accept responsibility. That is why I have submitted that it creates, the rule creates a powerful disincentive to take shortcuts. It creates an incentive on bidders to make sure that they act properly and regularly.
You know, Mr. Marcus, following on my brother's question, the more I think about your submission, the more shocked I become. Because, you know, I seem to recall that what informed the principle is the following. Ordinarily, a lawful contractor in the position of CPS ought to have been entitled to an adjustment of what they had charged SASSA. But precisely because the contract was unlawful, they could not be allowed to benefit like a contractor whose contract is lawful. But if as a business entity, you say to them, no profit. Remember, they are there for business. You must allow them to survive. There must be something business-like about their involvement in this contract. But if you pull that out, wow, then we caught in trouble, aren't we?
Well, it depends on how the courts...
Particularly in view of the submissions you've just made,
Yes.
that but for the BEE aspect, you really can't fault them for the illegality of the contract.
Well,
It would be quite extraordinary.
Chief Justice, as it was put in Black Sash 1, the premise, this is the words that this court actually used, the equilibrium was the premise of the court's previous remedial order. It is just and equitable to continue on that basis. Now, it is open to this court, I accept. It is open to this court, after the accounting exercise is done, to say, well, you have made an admitted profit of 700 million. We can either order you to pay back that 700 million in full, or we can order that you pay back some lesser amount. I accept that it is open to the court to do that. But what in our submission is not open to interpretation is that there should be no payback whatsoever, because that would defeat the very purpose of the no-profit principle.
Justice and equity, isn't that all the more reason for your client to start at the High Court so that they can grapple with how justice and equity impacts on the amount payable, if any amount has to be paid at all. And everybody can have the opportunity to express themselves fully and properly on this matter.
Chief Justice, if I may just add on that, everybody can then have an appeal if they are unhappy with the decision of the High Court, unlike if we decide the matter.
Yes. This court has clearly got a strong appetite for this case. Chief Justice, let me make this submission.
Mr. Marcus, just to add to this,
yes.
we're busy with an urgent application dealing with what has been characterized as ensuring that the department and SASSA fulfill their constitutional obligations for the grant of payments. My question is simply, will anything that you ask for, will this issue that you ask us to adjudicate help or hinder in that? And is there any reason why it can't be done later or in different proceedings?
Justice Fruderman, it's urgent for one reason I've already articulated, not necessarily the order to pay back, but an explanation that the underlying principle does require payback, and that is for purposes of the negotiation going forward. So I accept that I cannot press the court to say it is terribly urgent that they order now that the 700 million be paid back. I do draw attention to this, though. CPS has made clear in its affidavits that it does not currently have capital reserves sufficient to carry a projected operating loss of 70 million rand per month if it does not get a price increase. It says that in its supplementary answering affidavit in volume A 4.1 at page 382, paragraphs 18-19. What this suggests, this is very worrying, because what it suggests is either CPS has not ring-fenced its admitted profits, or, as my learned friend Mr. Budlander has pointed out, that it has passed these profits on to Net One, who appears to have derived a licensing profit of some 1 billion
I'm sorry
rand.
to interrupt. That may be so, or it may not be so. How does that affect whether we're going to grant this order for the continuation for 6 months or not?
Justice Fruderman, there is nobody in this court that I understand to dispute that the court really is left with little or no option but to grant that extension. The only debate is the conditions under which that extension is granted, and that is what I and my learned friend Mr. Budlander have been addressing.
Why should it be a condition to the extension?
Well, because if it is not made a condition to an extension, it would first of all dilute the no profit principle to something meaningless.
No.
Yes.
If it's not a condition, but you go to another court.
Oh, I beg your pardon.
What's the problem?
Well, Justice Zondo, it may not be a problem other than dragging out a process which has taken a long period of time, provided that this court makes clear what it means, or what it did mean, by the no profit principle. Because
Yes,
there is a
but-
very stark difference.
But is there a dispute at the moment about what that principle means?
Oh, yes. Oh, very much so, Justice Zondo.
What is the dispute?
The dispute is, it is as stark as this. CPS says they are entitled to profit and they are entitled to retain their profit. We say that is a misinterpretation of the three orders.
Oh, okay. No,
Yeah.
I
Yes.
understand
So,
that part.
so while I accept, Justice Zondo, that it is not imperative for purposes of this extension for this court now to order the repayment of the 700 million rand, what I do with respect submit is it is critically important for this court to articulate what is meant by those orders. And you've heard my arguments on
To
that.
what end, if it can be done later? And more importantly, after all pay 1, 2, 3, and black sash,
Yes.
there was no crisis when no order for payment was made. Why can't this wait its turn and go to the High Court so that a process can then start? And that articulation could then happen.
Chief Justice, I am not suggesting that it cannot be done in the High Court going forward.
Appropriately done in the High Court.
Provided the
Best done
yes.
in the High Court.
Provided the High Court knows, consequent upon the judgment that will be rendered in this matter, what the parameters of the debate are. It would be, we respectfully submit, not appropriate if this matter was simply left in the air so that this very sharp dispute as to what is meant were left standing. Recovery, let me use that term, can be done, I accept, in the High Court, but it can also be done in this court, at least in relation to the admitted 700 million.
Why can't the High Court deal with the matter without any pronouncement by this court on the interpretation? I thought that one court can interpret an order of another court, and obviously in a case such as this, if the High Court gives a particular interpretation and a certain result happens, and there's an aggrieved party and leave is granted, it might end up here, and this court would at that stage deal with the matter with the benefit of all the judgments of the courts below.
Justice Zondo, because fundamentally there is no, and this court has said as much, I can't remember the case, fundamentally when it comes to interpreting its own order, there is no court better equipped to do so than this court which granted the order. I know that you have said this somewhere, I just can't remember where.
No, that must be right, yes. But that doesn't say the High Court can't do it. It just says the best court to do it is this court.
Correct.
But it doesn't necessarily mean it can't do it. And the question is, as my colleague Justice Frenneman says, we are dealing with an urgent application for an extension, and why should we really have a lot of time taken about attaching a condition in regard to something that can actually be dealt with in due course
Justice
by
Zondo,
another court?
I accept it can be dealt with in the High Court. I would merely urge this court to make clear what the parameters of the no profit principle are, because otherwise, and with respect, this court has seen enough to know what I'm about to say is true. Otherwise, we have the spectre of incessant litigation in circumstances where I would submit the prudent use of judicial resources would be best served by at least this court articulating what the parameters of the no profit principle are.
And what do you have in mind in that regard, Mr. Marcus?
Are
you thinking, for example, about us saying we exclude what Mr. Badlander referred to, profits made by other subsidiaries of Net 1, which profits have since been remitted to Net 1. Is that the delineation that you would want us to do? And if that is so, is it appropriate for us to do that in this kind of case? Because if you are not, then that leaves you with only one question, and that's the question of interpreting our order.
Yes.
And the Deputy Chief Justice has, in my view, correctly said the High Court can do that.
What we are seeking in that regard, Justice Madlanga, is for an explanation, or a determination, perhaps is the better word, by this court, that the no profit principle in relation to the admitted profits of 700 million rand means that they must be repaid. That's what we are looking for. In relation to the Net 1 subsidiaries and Net 1 itself deriving the billion rand profit from licensing.
That's not the same thing as parameters. You said we must delineate parameters. Saying we must order CPS to pay, that's, unless I misunderstood you. I thought you wanted us to clarify, define what we had in mind in making this order, but not necessarily actually make an order that says pay.
I certainly invite the court to make it clear that the no profit principle means you cannot retain your profits, and once they are audited, they must be paid back. That is, I don't want there to be any equivocation on our side on that score. That is what we are seeking. Now, we might be held to be wrong.
Sorry, I'm not carrying. I just want us not to talk at cross purposes. Yes. I understood that to be your initial position, but after my colleagues engaged you, you then got to a point where you said you would like the court to delineate parameters. So I thought you want us to clarify what exactly our order meant. That's where I am. I'm not at all suggesting that you never asked that there should be payment. So it's more what exactly you meant by us delineating parameters.
I said that, Justice Madlanga, in the context of the proposed negotiation between CPS and Treasury concerning the cost going forward during this period of extension. What we submit is that this court should lay down that the parameters of that negotiation are subject to the no profit principle. In other words, what Treasury is directed to consider is what the break-even point would be, and to identify that point and to report back to the court on what that point is. Let me put it slightly differently. We do not accept that the no profit principle would permit CPS to negotiate anything other than a break-even fee per beneficiary. And those are the parameters I had in mind. Chief Justice, that only leaves, and I can be very brief on this, the question of costs. We make the following points. The first is we had to come to court on the back of a shockingly deficient application by SASSA, which was not only late, and I'm going to say something about this because Justice Zondo and others have picked up on the lateness going back to November. It was not only late, but it was also materially deficient. SASSA, this doesn't go back to 18 August, as our learned friends would have it. In fact, it goes back to the 3rd of November, 2017, and we give you the references in our heads of argument. If I could perhaps just take you to it. In our heads of argument at page 15, at paragraph 27.6, where we point out that the expert panel made it clear that at a meeting with it on 3 November, SASSA conceded that it would not be able to ensure full takeover from CPS on 1 April. Similarly, at a meeting held on 7 November, attended by the South African Reserve Bank, National Treasury, SAPO, and SASSA, it was concluded that, and quote, SAPO will not be in a position to start paying grants on their own as from 1 April 2018, and SASSA will not be able to finalize all their processes to ensure that grants are paid by 1 April 2018. So it in fact goes back to virtually the beginning of November, and they launched their application on the 6th of February 2018. When they did launch their application, this court was simply not placed in possession of the full information. SASSA did not disclose the full extent of the services that CPS would be required to perform. Were it not, we respectfully submit, for the interventions of the Black Sash and Freedom Under Law, a whole range of possibilities foreshadowed by the expert panel would simply have fallen through the cracks. So we submit we actually had to come to court. Freedom Under Law is an actual party to this litigation, having been admitted as such, as is the Black Sash. We have submitted in our heads of argument that this kind of behavior, which is not the first time, as this court only too well knows, justifies a punitive order of costs, but at a minimum, this is a case where SASSA, who comes to court seeking an indulgence after all, must bear the costs, at least the party and party costs. We would submit the attorney-client costs as well. Chief Justice, we have prepared a draft order. It has the concurrence of the Black Sash, although there is a part of it which requires amplification, as you foreshadowed before the adjournment. It also has, this will come as a shock to you, it also has the concurrence of SASSA, save for the last paragraph in which we seek costs. Could I hand the order to the court for its consideration?
Please do.
As I say, it is a consensus order, at least amongst 3 parties, save in relation to the question of costs.
Is there anybody who disagrees, any of the parties? Because otherwise that will save us arguments that we ought not to listen to.
CPS, it currently contains the order
Yes.
to repay the 700 million. CPS disagrees with that.
Okay.
I'm not entirely sure what else they disagree with. I think that there is likely to be consensus on just about everything else.
Well, I just want to know what is it you disagree on, so that we don't have Mr. Morrison and Mr. Bava coming here raising arguments in relation to which there is already agreement.
Yes.
What do you disagree on? Okay, 700 million, what else?
I only disagree with SASSA on the very last paragraph,
Costs.
which is the question of cost. So as far as Black Sash, freedom under law, and SASSA are concerned, there's only one disagreement. That is the last paragraph of the order. As far as CPS is concerned, there will certainly be disagreement on the repayment of the 700 million. My learned friend must speak for himself, but I don't think there'll be disagreement on anything else.
Mr. Marcus, should we not extend the no-profit principle to costs as well?
With respect, not. Anything else?
3, council?
Yes.
So that's your proposal?
Yes.
All right, okay. We'll reflect on that.
Thank you, Chief Justice.
Yes. You know the normal trend is 2, we'll reflect.
Yes.
Yes. Thank you, Mr. Marcus.
Those are my submissions.
Thank you. Mr. Morrison? Or is it, yeah, you are next.
May it please the court.
I know that you have your 10 minutes, but is it correct that you disagree on 2 points? So there's costs and 700 million, or coupled with the treasury issue?
There are detailed differences only on the question of detail, Chief Justice, which flow from the fact that CPS is the operational entity. So there are not so much differences in principle as differences in detail.
No, I was only saying, trying to have you focus on issues that in relation to which there is disagreement.
Yes.
Because sometimes council, and it has happened today, give us the kind of detail that really don't help us to resolve the difficulties that confront us. I just want to identify problem areas so that we know what is it that you are going to address and what you need to address.
As the court pleases. What we want to address is firstly our draft order, which we've distributed and we put together for purposes of assisting the court to come to a conclusion.
But that will be points of difference only, not the whole order.
That would be points of difference, correct. Does the court have it? It's at page A622.
Proceed, Mr. Morrison.
As the court pleases. The first is paragraph 2, which extends the contract on its current terms and conditions for 6 months in respect of the cash payment. The second is an essential requirement which we find common to all the orders at 2.1, which is that we be advised as CPS of what's required. And that has found commonality across all the orders. So the first component of the order is common to all, and that is that SASSA tell us exactly what it is within 5 days they want done. And that's the starting point of any engineering contract, because this is really what we're dealing with, is an engineering contract. We're defining the scope of the work, and until such time as SASSA tells us what we required to do, we're not in a position to respond. And then the continuation of the contract will take place for the 6 months, and Treasury will take control of the price for purposes of ensuring that no loss is made and no unreasonable price is charged. And in that regard, I'll come to my learned friend's submissions on the profit argument shortly. But we are in agreement on the auditing, and we're in agreement on the reporting obligations. But in our submission, the appropriate formulation for the order is as per the draft prepared by ourselves, and in particular, we would draw attention to what would seem like a minor point, but at paragraph 4, the calculation of time is to be done in calendar days, because we've got public holidays coming up and we don't want disputes over what the computation of time is going to be done with, and people coming back and saying that they had court days within which to do things. And that is our submission in regard to the manner in which the relief should be dealt with. The reason why we make the submission is because CPS has got, despite all the criticisms of the contract that was awarded to it, a remarkably good track record in delivering these services. And we would urge the court to accept what CPS says it can live with as the appropriate definition of what the services should be, because CPS is the entity that ultimately, for the extended period, that is going to have to implement these. And it seeks only an opportunity to go to Treasury to negotiate a reasonable remuneration for itself, and it seeks an articulation in this order of the principle that no loss should be made by it. And to use the analogy and to pick up on Justice Froneman's question to my learned friend, Mr. Marcus, what are we doing debating profit in relation to an urgent application to save the social grant payment system? CPS's approach is we must first look to the floor before we look to the ceiling. And the flaw that lies at the foot of this argument and at the foot of this structure is in a passage that my learned friend, Mr. Marcus, had reference to, but we were surprised at the way in which he used it, because this defines the greatest danger in this hearing. It's at page 382, where CPS says that if we're obliged to trade at a loss, we will be unable to trade beyond the end of May on the new system. So let me give the court the benefit of a brief chronology, if I may, because the first and most important date is the one that will end the contract on the 31st of March. If nothing lies beyond that, we know the floor falls out of the building. And everybody faces the disaster that we all know lies ahead. And that's why, of course, the application can't be refused. The end of May is when CPS runs out of money if it's not able to negotiate a price. And we submit that should be done by going to Treasury. We know the Treasury is equipped both with the means and the skills to debate an appropriate and reasonable remuneration for purposes of deciding what CPS should get for the extended period. Then, sticking with the concept of a chronology.
But how is it that you run out of money if there has been...
He's still protected.
Sorry, I hadn't realized.
If I can take that up, if I may, Chief Justice.
Then colleagues are free to put questions to you.
Yes, I'm happy to forfeit the protection at the advanced stage of the debate. It's at 382. The assessment that, A382, the assessment that CPS makes is that if it's required to continue operating, its loss will be 70 million rand per month. If it's just distributing cash grants, an electronic component is no longer part of what it's earning, because the electronic component is the part that subsidizes the cash part. So the electronic part will move to the post office and the cash part will remain with it. That's the most expensive part of its operations. If it continues to be paid only 16.44 Rand per beneficiary during the time of distribution of the cash, it will go under at 70 million Rand per month. Those resources will be exhausted by the end of May. So critical timeline number 1, 31 March, critical timeline number 2, end of May, because if CPS is not remunerated adequately in that time or a price agreed upon to enable it to continue trading, then the floor falls out 2 months later.
Forgive my ignorance. What do you mean the resources will be exhausted? Where would they have come from if they are not adequate in the first place?
It's the CPS cash reserves, Chief Justice.
Or what it already has
What
in
it already
reserves?
has, yes.
Oh, I see.
What the deponent says is, I estimate the CPS will only have sufficient cash reserves to cover its operational costs until 31 May 2018, assuming...
Is it reserves plus what would be coming in, or reserves only?
Assuming...
Have you added what would be coming in
We did.
to the reserves?
We did.
Okay.
Because it says, assuming SASSA duly pays its invoice for March 2018. And there's not a lot of good news in this court, but maybe take a step back and look at some of the good news and urge why the court should adopt CPS's recommendations. The good news, as indicated in Justice Froneman's judgment and the court's judgment in All Pay 2, is that this has been a spectacular achievement in the distribution of the social grants over the 5-year period, despite the irregularities. And the spectacular achievement is over 72 months now. And in those 72 months, R750 billion has been distributed by CPS. It's just short of R750 billion. It's 720 billion rand. It's been distributed over the 72 months, the 5 years of the contract, and the further year of its extension. CPS has ensured the distribution of those grants to the many beneficiaries efficiently and effectively. It is a reliable partner in
May I interrupt you,
solution.
Mr. Morrison?
as the
You
court
may be spending time on the track record of CPS when in fact the problematic area relates to whether or not it should pay back money or not. Because if the track record is good, we'll see it. Unless you really have to spend some time on how well it has performed.
No. I'll take your guidance, Chief Justice, and I'll go straight to my learned friend, Mr. Gilbert's argument.
Mr. Morrison, when you start with that, I would like to know from the outset, would you like this court to make a determination on whether the 700 million or whatever it is payable or not, or is your submission that it can be better done elsewhere and on a different occasion?
It is the latter, Justice Froneman, and it's set out in great detail with extensive references to the authorities of this court in our heads of argument, in which we say that is by far and away the most appropriate thing to do, is to leave it to an ordinary process to commence so that this court can deal with it through the High Court and receive it ultimately as an appeal record. And there are many instances where the authorities have confirmed that, and those are set out in extensio in our heads of argument. But in dealing with my learned friend Mr. Gilbert's argument, and having...
Mr. Marcus.
Mr. Marcus, I beg your pardon. I've got a note of his Christian name here. I beg your pardon. Mr. Marcus. If the end point is the 31st of May, and my learned friend knows that because he's referred to it, is it responsible? Is it viable to suggest that CPS pay back 700 million by the 1st of April? Because that's what Fools wants. And one asks oneself, April Fool's Day, perhaps, because how can it possibly be responsible? How can it be anything other than extremely reckless for Fool to insist that an entity that it knows has got cash reserves that will take it to the end of May to pay back 700 million by the 1st of April? In our submission, it's an opportunistic argument, and it's based on a misconception of the All Pay 2 judgment. And here again, we are assisted by time. A simple analysis of the dates. The contract starts in February 2012 and ends in February 2017. All Pay 1 is decided on September 2013, about a year and 6 months after the contract started. All Pay 2, the remedy decision is February 2014. It's in the remedy decision that the genesis of this concept of the no-profit principle arises. All Pay 3 is in March 2015, Black Sash 1 is in March 2017, and Black Sash 2 is in June 2017. Our submission is that the entire debate about whether a profit should be made is because there was the concept of a benefit from an unlawful contract raised in All Pay 2. And in All Pay 2, the contract was young. There was mention in All Pay 2 of an outlay of 1.4 billion rand startup costs.
I'm sorry to interrupt you, Mr. Is that your alternative argument, or are you staying with your main argument, which is this is not the right forum where this issue should be dealt with? It should be dealt with by the High Court.
Yes.
Is that your alternative argument now,
Yes.
or is it part of the main?
It's the alternative.
Oh.
It's the alternative. The main argument is set out in full in the heads, and I don't want to spend any greater time on that. The reasons why this court shouldn't hear this debate are self-evident in our submission. But moving on to the merits of the argument to the extent that it's required, we make the submission that a proper interpretation of All Pay 2 demonstrates that what the court was there concerned with was once a contracting party early in its contract has not yet made up the full investment that it made in order to get the contract in the first place, will it be out of pocket if the contract is terminated earlier than the full contractual term? That was the true debate, as we understand the judgment in All Pay 2, about whether there would be a benefit and the possibility of benefiting from an unlawful contract or making a loss from an unlawful contract.
I don't know if it helps because what's in your reserves, and pardon my ignorance about financial matters, but I think what's in your reserves depends on how you use money as it comes in. I mean, directors may decide each, all right, 11, buy a Rolls Royce. It's going to determine how much will ultimately be left and how much you pay yourselves. No. From now henceforth, we'll be earning 10 million rands per month. So I think the details in relation to the reserves ought to belong elsewhere, don't they?
Indeed, sir.
Yes.
I'll leave that point aside, if I may mention.
It's not an automatic thing that because this is what you charge per month, then the reserves will be this. It depends on a number of things in between.
Indeed,
what
sir.
ends up being the reserve and the utilization of the money as it comes in.
Yes. Hence the wisdom of the court in having the audits done. And my learned friend makes the suggestion that the audits were there to eliminate profits. In our submission, that is not so, that the court's questions were correctly focused on the question of reasonableness, and the issue was whether the monies that were to be audited reflected a reasonable remuneration, that there was no abuse, that there was no corruption, and indeed we would emphasize again and again that All Pay has not, I beg your pardon, CPS has not been found guilty of any corruption or any misdemeanor of any sort other than an irregularity which was on the part of SASSA. And the record of CPS is, barring the irregularities, entirely devoid of moral turpitude. And in fact, it has rendered a service to this country that has enabled the cash payment services to remain intact for a period longer than the contract. It contracted for at the same price throughout that time. And the criticisms of cash paymaster services, which we've seen in our learned friends' heads, must be tempered with a reflection on the reality that the reason why the contract was labeled as unlawful was only those two irregularities which lay at the door of SASSA and had nothing to do with CPS's conduct in our submission. I would finally...
So, Mr. Morrison, is your argument with regard to the no profit principle that the court sought to strike a balance between not putting CPS in a position where it would incur losses, but also not allowing it to earn more than just a reasonable profit. In other words, while ordinarily it may have been entitled, if it was a lawful contract, to be greedy, but you say you are not going to be allowed to be greedy because this contract is not lawful, but we are not saying operate at a loss, just a reasonable profit.
Indeed so, Justice Zondo. We would make reference also to the fact that a number of the parties that would be affected by the no-profit principle were the order made by, requested by full made are not before the court. The subsidiaries are not here. And we would make reference also to the fact that this is a request that surfaced in an answering affidavit and would open the floodgates to a disaster in the procurement law, because every company that contracts with the state might face the same fate if the profits were taken from CPS. And that would throw procurement law in our submission into disarray and make partnerships between the state and private enterprise exceedingly more troublesome. And we would conclude in that regard that the court has on a number of occasions re-emphasized, including in the minority judgment of Justice Madlanga, that whenever this contract is extended, it is extended on the same terms and conditions. And that is in essence the death knell for the profit argument, because the profit is built into the contract. And if the same terms and conditions continue forward, then the profit is carried forward automatically by the terms of the order.
Well, that assumes that the initial contract subject to our earlier orders allows a measure of profit.
Indeed, sir.
I would just like to know why, if the general principle is that CPS shouldn't suffer a loss, why does that equate to that they're entitled to a profit? I can understand the argument that they shouldn't operate at a loss, and that therefore they should be remunerated for whatever services they offer at what is a reasonable cost of those services. But I fail to follow the logic that they're entitled to some kind of profit margin.
In this case, Justice Froneman, we would rely simply on the fact that the terms and conditions of the contract were carried forward. And we know as a matter of fact now that that did generate profit. So we're not arguing so much that that CPS is entitled to a profit.
It generated profit, but the court ordered that that profit must be disclosed and verified.
May I just finish the one point? CPS is arguing that it's entitled to the benefits of its contract. It's a contractual right. It's a component of its right, its constitutional right to dignity. It had the contract. The court kept the contract alive. As an incident of the contract, there is a profit earned. But the constitutional right that is impaired by my learned friend's argument is actually the right to dignity, inherent in the right to be a contracting party and the freedom of contract that is enjoyed. There's no right to profit, but there is a right to have the contract that is made enforced by an order of this court a year beyond its term operate in the manner that it was written in its terms and conditions. And there one has to grasp the nettle of whether the contract is practically lawful or not. And practically, because the declaration of invalidity has been suspended, it's practically lawful. And therefore, practically all of its terms and conditions, despite the legal invalidity, are carried into effect. And one of the effects of that is that because they're an efficient business and they contract in a manner that keeps them in business, they earn a profit from the services that they render. And those services, as we've said repeatedly, have done the country a great deal of good. If I may just take an instruction.
I'm not sure where this right, where CPS has some sort of right to dignity.
I beg your pardon, Justice Kishore.
Where do you get this right to dignity for CPS?
The CPS is a contracting party, and in excuse me, what's the contract? In Barkhuizen and Napier, it's pointed out that the rights of a contracting party are part of the right to dignity. And that's where we draw the link. But it's essentially a right to the contract. And the benefits of the contract, which have been kept alive. May I then turn to my learned friend Mr. Budlander's argument. The first point we'd like to make in regard to the Black Sash's argument is that there is no card information carryover from the one card to the other. They are separate processes. They're under separate Financial Services Board rules. They're licensed financial services providers. And the obvious conclusion to draw from this is that if there was a straight carryover of cards, there would be the same number of cards in the SASSA system as there are in the EPE system, and they're not. There would be 10 million EPE cards if we were carrying the information over from one to the other. They are entirely separate marketing team working with EPE, and the marketing takes place outside of the payment area. And that's confirmed by CPS in their papers.
The protection, do you disagree? Or are you in agreement about the reinforcement of the protective mechanism?
We're in agreement.
So, wouldn't you consider going to the next point then, if you are in agreement? Regardless of how you may differ on the details, if you are agreed on how to rephrase the order so that the beneficiaries are protected, then the finer details might just be for our intellectual excitement, isn't it?
As the court pleases. Before I leave this point, may I just make one other point in relation to an observation that was made in regard to my learned friend Mr. Budlander's argument, and that is CPS is not laughing.
It's not?
Laughing.
Yes.
CPS actually prompted SASSA in a letter of the 27th of December to address this situation, and CPS has been endeavoring to bring the situation to a successful finality for some time. And its prolonged involvement, particularly now that its contract is ending, is a difficult situation for it to be in. And it's endeavoring through myself and my learned friends and my learned attorneys to communicate a successful solution to the problem that the court and the country faces through its draft order. What my learned friend Mr. Budlander gave us after the address that he made to the court is that the following protection would apply, and one could note this under Black Sash orders. I just have a handwritten note, may I beg leave to read it into the record. CPS and SASSA must comply with Regulation 21(1)A and the regulation under the Social Assistance Act by paying a social grant into a bank account at a beneficiary or institution where the beneficiary resides, only where the beneficiary has requested this in writing as contemplated in Regulation 21(1)A Roman 1, with which we have no difficulty. Paragraph 1 applies whether the payment of the said grant is made directly into a EasyPay EPE Everywhere account or paid into a Grindrod SASSA account and then transferred into an EasyPay Everywhere account, with which we have no difficulty.
I had pleaded with counsel to focus on areas of disagreement.
It's just that the court hasn't had this, this before it, Chief Justice. The areas that we do have difficulty, I'm coming to straight away. The suggestion is by the Black Sash that no deductions or debit orders may be made from EasyPay Everywhere accounts on a social grant beneficiary, at a social grant beneficiary other than one where Regulation 1A has been complied with, or two where the deduction takes the form of a cash withdrawal. And item 4, with which we do have a difficulty, is the alternative that the no deduction or debit order for the benefit of a subsidiary or net one may be made. And the reason why we object to those last two is because they are the subject of proceedings before the Supreme Court of Appeal following the decision in the Pretoria High Court. And we would submit that this court should not go into that area of protecting the beneficiaries in a manner that's already before the Supreme Court of Appeal. And then insofar as costs are concerned, I would just point out that we are in agreement with our learned friend, Mr. Marcus's submission that SASSA should pay costs on the attorney-client basis.
Costs of how many, counsel?
Cost of 3 counsel, if we may. And although I know I've been admonished a number of times to focus on the points of difference, the one feature that is largely consensual but does require emphasis because of a time limit detail is paragraph 2.1 of our order at A623, which is that we must be informed as CPS within 1 week of the requirements of SASSA and SAPO and the South African Post Office, because we've got until the end of March in which to gear up, make the cash available in the outlying areas, get the trucks out there, get the software ready to do what is essentially a new contract at a new price with which we will be negotiating with Treasury, and we need to know as soon as possible, and we've stipulated 1 week, which we don't think is unreasonable if one has regard to the meetings that have been held between SASSA and CPS recently, and the slideshow that's attached to our latest affidavit, which demonstrates that they are coming to an understanding of what's going to be required under this new contract that will endure for the next 6 months.
Thank you, Mr. Morrison.
As the court pleases.
Mr. Bafa, as you come, you may consider whether, in view of what has been said already, you're just presenting yourself for possible questions, or whether you want to add to the debate. It's your prerogative.
Thank you. Sorry, Justice. I was busy walking, so I didn't hear the entire.
I was saying that a lot has transpired already.
Yes.
It's obviously open to you to say, I present myself for questions, my argument is in the written submissions, or to add your voice to the debate. It's all up to you.
I wish to add my voice to try and be of assistance to this court. Chief Justice, you will recall that when we came in as SAPO, we came in at a critical juncture where we sought to provide an alternative where we thought the state was held at ransom. And that was our fundamental intervention in the matter as amicus curiae. Today we stand in perhaps a different capacity, and that is the service provider to SASSA. And this is the shift, perhaps, in the entire matter.
Still need to be protected for 5 minutes, or can we interrupt you?
I think an engagement will be fine, Chief Justice.
Are you ready to start on the 1st of April?
Yes, we are. We are in the sense that, as we indicated when we first made the submission, that we would require one of 2 things. When we first approached this court as amicus curiae, we said we could take it off over the entire process within 1 month on an electronic voucher system, which was being carried out in the Eastern Cape. We said for the entire electronic system to be transferred, we would require a period of approximately 9 months. That was our initial submission. So, as we stand currently, in terms of the technical team and in terms of the transition period, we are able to, SAPO is able to start as from the 1st of April on a diminishing scale, meaning we need the assistance of CPS to continue paying so that no beneficiary remains unpaid.
I don't understand. Okay. What is it that CPS will be required to do, which you have undertaken as your exclusive responsibility with effect from the 1st of April? What is it that you will be sharing?
Okay. Perhaps I need to step a step back. So
apart from what CPS understands to be its exclusive responsibility with effect from the 1st of April,
yes.
Which part of your own responsibility do you intend to share with CPS, and is that issue resolved? Is it settled between the 3 of you, including SASSA?
Okay, so if I can just step back one. there are two different modalities of payments. One is the electronic payments and the other ones are the cash payments. The SASSA has approached the court for an extension as far as the cash payments are concerned, and we have requested that it be extended to the electronic payments as well. And there's no objection by any party to that.
I don't understand. You see, Mr. Bava, I understand that the CPS is supposed to continue with the cash payment.
Correct.
What I seek to understand is, as far as the electronic responsibility is concerned, how much of it are you taking over immediately and how much of it is going to still have to be carried out by CPS? Is that settled?
Well, it is, within SAPO, it's settled. It requires CPS to provide, the contracting basis is SAPO contracts with SASSA. SASSA then engages with CPS. So there is no tripartite agreement, which was one of the questions that you perhaps posed, as far as that is concerned. As far as SAPO's readiness to engage and what it requires is the following, is that SAPO is prepared and is ready to start dealing with the entire electronic, and we have prepared an additional affidavit by Mr. van der Merwe, which is a technical affidavit, which we deemed necessary to place before this court to indicate SAPO's readiness to take over electronic payments. However, it is going to be on a diminishing scale.
Okay, just for a simple man like me, I'm sorry to interrupt you. I'm sure you understand I've been interrupting your colleagues. You see, it's some 5.6 or 5.6 million beneficiaries that you are supposed to service?
Correct.
How many of them will SAPO be able to service with effect from the 1st of April?
Well, the process works on a transition process. So this entire transition process is not on day one, everything cuts off or goes over. And this is where the entire migration takes place. So it's a migration of beneficiaries from the CPS system onto the SASSA SAPO system, which ultimately is a ring-fence system which will eventually go to SASSA. So it's not that all the 5.6 million beneficiaries will automatically or be transferred onto the system or receive payment from SAPO.
I'm sorry, Mr. Bava. I got that sense. I just wanted a simple answer.
Sure.
In terms of your state of readiness as you know it,
yes,
say for the month of April, how many of the 6.odd million beneficiaries will SAPO be in a position to service unassisted by CPS, and how many will then still have to be serviced by CPS? Okay. That's all.
So in terms of our program that we've submitted to the court, initially there will be 250,000 cards issued, the EMV cards or EPE cards. And then there will be an additional 250,000 on the 9th of April, and then 250,000 cards issued per day thereafter until 10 million cards are issued. So that is the unrolling of the process. That's how it's, where in terms of the initial migration.
Proceed with your submissions, Mr. Bava. Deal with whatever it is you really wanted to deal with.
Yes. Chief Justice, just to add an additional aspect to this, it is technical. It has, in terms of a technical affidavit that we have submitted to this court, and in terms of all of those processes, what SAPO does not want is that there is no backup from CPS, and that is why it is seeking that extension as far as electronic payments
are concerned. That I understand. Yes. You know, I believe that things like this are capable of being simplified for an average person like me to understand. You are assuming responsibility for X million number of people.
Correct.
And you know your own state of readiness. I expected you to say, for the month of April, on the 1st, we will only be able to service 2 people. By the 15th, we will be able to service 500,000 people. Yes. By the end of April, we would have been able to service 1 million people.
Yes.
And it's only by August the 3 million would be serviced and the September the 30th, which is the cutoff date in relation to this 5.6 or 5.7 million, then everybody would be serviced by a SAPO in the category allocated to us.
Sure,
But it doesn't look like you're able to say that. That is why I said, no, proceed with
Chief
your,
Justice,
the
perhaps
points that you wanted to deal
yes,
with.
perhaps I haven't expressed myself clearly. What I said is that 250,000 cards are produced as at 16th March, 250,000 cards as at 9th April, and every day after that 250,000 cards, meaning that we will be able to, until 10 million cards are ultimately produced. It means it's an electronic system. And once the fingerprint parties come in, so depending on how many people come in, but as from the 16th of April onwards, there are 250,000 cards produced per day. So that is the amount that SAPO will be able to service. Thank you.
Proceed, Mr.
Yes.
I'm sorry, could I just ask you, is there any dispute between any of the parties about the relief that you are seeking?
No, there is not. Not that we understand.
So you don't have any problem?
We don't have, but we just want to discuss the various draft orders that are before you and tell you where, as Chief Justice has requested, where our points of departure are. As far as what CPS has produced as a draft order and what Freedom Under Law has produced.
My brother Froneman asked, do you disagree with the draft orders? I thought you said no. Or did I misunderstand your answer? And maybe the question.
I thought the question was whether anybody objected to our relief.
Or
that we are
your
seeking.
own relief?
Correct.
Do you object to the relief proposed by others? And if so, which part of whose proposal?
Yes, so what I want to do is that the relief is not objected by any party as far as electronic payments are concerned. What I wish to do is to discuss the points of departure we have in terms of the proposals by draft orders that are before this court.
Focusing on points of disagreement.
That is as you have requested.
I'm sorry, Mr. Bava, before you do that.
Sure. Justice Chapter.
Can you clarify this for me?
Yes.
What SAPO 6, it's a relief that differs from what SASSA 6.
Correct.
And that relief is for the benefit of SAPO, not for the benefit of beneficiaries. Now, why does SAPO comes in, not as a party, but as an amicus?
Initially, Justice Jafta, we came in as an amicus. At that stage, we were not involved in the process or any of the bidding process. But because there was a national crisis, SAPO had a solution to propose to the court and come to the assistance as a friend of the court. So at that stage, on the 15th of March last year, when SAPO approached this court, it approached it as an amicus. Since then, what has transpired is that SASSA then engaged, and with leave of this court, and perhaps also an indication by this court, that SAPO would be a valuable contributor to alleviating the national crisis. SAPO then came in as now a service provider and was joined in these proceedings.
But ordinarily, an amicus doesn't come in to seek an order that advances its own interests. An amicus comes in to help the court to arrive at a correct decision. So
Yes.
what really concerns me is that when SAPO realized that the relief sought by SASSA would not serve its purposes, why didn't SAPO seek leave to intervene as a party? Instead, it comes in as an amicus.
Thank you, Justice Jefter. Firstly, SAPO does not come in to serve its interests. It's the interest of providing, SAPO itself is an organ of state. And the proposal that we had submitted to the court right at the outset is the principle that needs to be engendered and fostered, is the working between government departments in order to save taxpayers' monies. So where there is competency and expertise within government departments, that must be used to contribute back to the fiscus. That was the...
I'm sorry to interrupt you, Mr. Baba. As I understand it, what SAPO is saying to us, it says, don't limit the extension of 6 months to the payment of cash benefits.
Correct.
Extend it in a sliding, declining degree also to the payment, electronic payment
Correct.
program.
Yes.
And that is sought for the base purposes of SAPO being enabled to perform its function.
Yes. Justice Jafta, in the broad perspective, perhaps that is correct, ultimately. But if we are to look at it fundamentally, that SAPO has entered into on a contracting basis where it could not provide any of the services until the 8th of December 2017, when the agreement was concluded. That was not in SAPO's hands. So in order to avoid the beneficiaries being prejudiced, and in order to ensure that the beneficiaries are paid the grants, SAPO comes to this court and says, the relief that SASSA seeks is very limited. If you only allow this, you will be catering for some of the beneficiaries, but not all. So a portion only the cash beneficiaries will be dealt with. We obviously don't want that crisis. And therefore, SAPO comes in and says, from the 8th of December, you can look at our track record, and we produced the technical report to say what should have taken place in about 4 to 6 months, SAPO has done in the process of 1.5 to 2 months. So SAPO clearly has the capacity to deliver. The point is, we cannot leave beneficiaries stranded. So on the more globular perspective of this, one sees that we ultimately, all the participants and the court, have to look towards the protection of the beneficiaries' interests. And that is why SAPO is approaching this court.
Baba, maybe you misunderstand my query. My query was very narrow, really,
yes,
as to the wisdom of seeking to be admitted as amicus as opposed to seeking to be admitted as a party. That was all my query.
Sure, Justice Jafta, we've been joined as the 7th respondent in these proceedings. So we haven't come as amicus, we come in as the respondent, as the 7th respondent.
I'm sorry, I just want to get the basics right.
Sure.
Do I have it right that there is a contract, an agreement between SASSA and SAPO that from the 1st of April, SAPO will provide payment to the grant beneficiaries of 5, 6 million, whatever that is?
Correct.
There is an agreement.
There is an agreement. Which was
Everybody agrees on the validity of the agreement. There's nothing that we have to say about the agreement.
No, there's nothing much that we have to say about the agreement, apart from one question that Justice Jafta posed, is that why didn't you perhaps come earlier, or why didn't you...
Yes, apart from that. The
Apart
validity
from
of the agreement is not. The performance of the agreement is not in issue.
No.
We don't have to say anything about it.
No, that is controlled by the Interministerial Committee as well. It's overseen by...
Just asking you,
yes,
the performance of the agreement,
no,
we don't have to do anything, we don't have to order anything in that regard.
It's not an issue at this time, at all.
Your suggested order, if I understood you correctly, is accepted by the other parties?
No, we don't know. It looks like from what the discussions have been here that it's not. But if we may take you to the point of departure in terms of all of these orders, we will demonstrate why there's dangers, lurking dangers in some of the orders proposed. And I just want to inquire, the Justices, we distributed the draft orders, which are the SAPO's draft orders, to yourselves. And if you do have copies in front of you, because there are three orders that we're now looking at, and that's Freedom Under Law, CPS, and SAPO's draft orders.
Order, Mr. Baba.
So, thank you. So if I may suggest that I want to go on the points of departure and state why SAPO's proposal is perhaps the better proposal of the three, or the best of the three. Firstly, the SAPO's proposal, as far as the draft order, refers back to the order of 17 March 2017 of this court. and it does not seek to deviate as far as the terms of such order are concerned, and I'm going to take you through that. And I'm cognizant of the fact that the Chief Justice has indicated that I should rather concentrate on the points of departure or difference as opposed to the points of commonality. So just let me go to CPS proposed order. CPS proposed order we submit seeks to expand the ambit to such an extent where it will create a lot of disputes. So, for example, if you grant me a moment. The first proviso at paragraph 2.1 of their proposal says, SASSA and SAPO shall advise CPS of all the services it is required to provide over the extension period and the period for which this will be required within 1 week of the date of this order. Now, it seems to cast it within the 1 week period, and what happens if disputes occur thereafter? Meaning, does CPS then approach the court? Does it then come and say, look, you didn't give me this within the 1 week period, and now there's additional services that we now need to perform. So how are we going to now perform these? They're not in terms of the order, and therefore there's a different mechanism. We have to come to a different agreement as far as those aspects are concerned. We make a proposal which says that the primary aspects could be done within a week, but there could be an ongoing process where the parties talk to each other about services that need to be provided. Then, paragraph 2.3, we find that this is a complete deviation from the 17th March order, and on the face of it, it doesn't appear to be so, but if we just read it closer. CPS may make representations to the National Treasury on a reasonable price for all the services it is required to continue to perform over the extension period. It then says, CPS and National Treasury shall endeavor to reach an agreement on a reasonable price for all the services that CPS is required to provide over the extension period and will report such agreement to this court within 30 days of CPS's representations of having been received by National Treasury. Then 2.5 is the clincher. It says, in the event that CPS and National Treasury fail to reach an agreement as contemplated in 2.4, CPS is entitled to approach this court on an urgent basis for further relief. So what they're saying is, as opposed to where this court initially said on the 17th of March, that this is submitted to Treasury. Treasury will then make a recommendation. Obviously, Treasury takes into account all the submissions made by CPS. It then submits that recommendation to court, and from there it proceeds further. Here it opens a mechanism for dispute. We are of the view that the 17th March 2017 order should be reverted to and should be sustained. In fact, in our draft order, what we say is that any area not covered by our agreement, which deals with the 17th March order, the 17th March orders survive, and that is crucial. Then 2.7 is also a dangerous clause we submit. It's a dangerous clause because what it does is it seeks to limit the liability of CPS only for 2 years and doesn't take the 5 years prior to that.
How does that affect your client?
Sorry.
How does that affect your client for you to be worried about it?
Well, Chief Justice, it does affect all of us, but more than that, fundamentally in terms of law, that it is a fundamental principle that where there is something that this court needs to consider in a particular matter, including a new case that might come about, that it is the duty to put that forward so that that can be taken into consideration. Whether the court accepts it or rejects it at the end of the day, it is a suggestion to avoid the court falling into a situation where perhaps this may not be taken into account.
I think the Chief Justice is suggesting to you that to the extent that it might not really affect your client, there are other counsel who are looking after the interests of their clients.
I do accept it, Deputy Chief
And
Justice.
also concerned that your time has run out.
Yes, I do accept that, but I believe that these are important considerations to put before the court. It is very important, I submit, that in a communication and an interaction process, that we put the proposals down for consideration. And thereafter, these points which have arisen to us and which we find to be problematic, especially in view of the fact that we were involved in the case as amicus curiae, and now we come as a respondent to this court. So, with your permission, Chief Justice.
Yes, as long as you are mindful of the fact that you no longer have time.
Yes. So, we submit that paragraph, clause 2.7 of that says from 1 April 2017 to 30 September 2018. It seeks to limit the contract only as far as the extension period is concerned and not the full 7 years of the contract if it was. Then, as far as freedom under law, we were only given this when Mr. Marcus stood up to argue his proposition. We did not have sight of this before. But at clause 2.3, at clause 2, or paragraph 2, the inclusion of the phase-in and phase-out process is not included. And we would submit that that phase-in and phase-out process be included as far as electronic payments are concerned. As far as clause 3 is concerned, here again, we believe that this is, the 5 days opens the situation up for possible dispute. And then from paragraph 7 onwards, we believe that until the end, all that should be excluded. In fact, at paragraph 9 onwards, we believe that that's asking for a judicial overreach, and that's a parliamentary function and it's asking this court to perform that. Clause 9.
Recommendations from the expert panel. 9 and 10.
Then those are submissions as far as those proposals are concerned. As far as costs are concerned, we believe that the cost should be reserved until the matter is finalized. There is just one aspect as far as the urgency is concerned. While there is, and we know that there is a different milieu as far as the political climate is concerned.
Until which matter is finalized?
Sorry, until the entire application is, as we requested, not this matter, but in its entirety.
Which other application now?
No, it's not another application. There are still going to be perhaps reports that might be submitted at certain stages as far as this matter goes to this court, and for determination. And there is still the 6-month period that is requested as an additional period for the extension of the invalidity of the contract. So we say until all of that is finalized, then the court may make an order.
Mr. Buffer, we're dealing here with an urgent application for the extension.
Yes.
And no other matter is before us.
I hear you, Justice Kampepe. I make no further submissions as far as costs are concerned. As far as urgency is concerned,
Is there any doubt that there is urgency?
no.
So,
No.
why are you making submissions on urgency?
I'm making a submission because it said SAPO was responsible for the matter not being brought to court earlier. And there I refer where it was said that SAPO had not concluded the cash payment and had not informed SASSA. Now, I must preface this by saying that there is a good working relationship with SAPO and SASSA. But I have to put in record that if you have reference to SASSA's own affidavit, and at A18, paragraph 21. I just would like to read that for the court.
Mr. Buffer, I'm sorry. Which point are you seeking to make and why?
Well, when the court considers the aspect as to whether SAPO had a role to play in the application not being brought earlier.
Is a cost order sought against SAPO?
I don't, it hasn't.
So,
but
how would this affect, how would whatever order we make as a result of what was said have a prejudicial effect?
Well, it's simply
on SAPO?
just to place the fact that as far back as September 2017, the issue that SAPO would not be able to do the cash payment was already dealt with.
No, please, in 1 minute roundup, because your time is long.
No,
up,
that's
Mr.
the last
Buffer.
submission.
Thank
Chief
you so
Justice.
much.
Thank you.
Thank you.
So I can get clarity. You said costs must be reserved. Now, I mean, are you talking about your own costs?
No. Yes, well, we not see, well, we're just making a submission that if you consider, if the court is considering the aspect of costs in this particular
Yeah, but
matter.
you were brought here as the, you say as the seventh respondent. So I just
Correct.
want to understand what you seek in relation to costs.
No, we do not see costs.
Thank you very much, Mr.
Thank you.
Buffer. Yes. Mr. Kazi, you still where you were? Oh, are you still where you were? I beg your pardon? Because you want to say something on behalf of the minister, even if you did not make any written submissions.
That is correct, Chief Justice.
What is it?
I would like to comment on the draft order handed up by full.
Which paragraph and which draft order?
It's the Freedom Under Law draft
Freedom
order.
Under Law
by
draft
Mr.
order.
Marcus.
Yes, can you read out the part that you want to comment on?
Yes, Chief Justice. Paragraph 3.1, the only submission would be that it should be SASSA and SAPO. And then paragraph 5.1, the submission would be that it, the reports to be filed by the Minister and SASSA should be every 8 weeks. And then paragraph 9, we'd simply like clarity from Mr. Marcus as to what the aim of that report is, and if it is to go to Parliament and to the court, exactly who is the decision-making authority on that report, and also whether there could be an amendment to that, that it also goes to the Minister or to the IMC, through which the Minister is supervising the SASSA work. The last... And
Mr.
that-
Marcus won't be able to clarify anything because his time is gone.
Well, then
It's only
we would
Mr. Kasi.
request
Maybe you
that
could
that-
have a private chat.
Chief Justice, we only received this after Mr. Marcus's submission, so I hadn't had a time to engage with him at all on this draft order, but those would be our only concerns. Thank you, Chief Justice.
Thank you. Mr. Kasim?
I will be very brief. Yes. Insofar as Mr. Budlender is concerned and his argument, I will ask the court to please have regard to the third report of SASSA, which
His
is
argument on what? Can you
Sorry.
remind us, please?
third report of SASSA of 17th November, pertinently dealt with in paragraph 5 at page C377, volume 12, and I'll just read the relevant portion. It's dealing with the EYE cards. In terms of Regulation 21.1a of the Social Assistance Regulation 21.1a, SASSA shall pay a social grant into a bank account of the beneficiary or an institution where the beneficiary resides subject to written authorization, which my learned friend referred to, and then under 542A, this is a crucial one, as from 1 December, SASSA would be collecting mandates from beneficiaries as per Regulation 21.1a to transfer social grant payments into their bank accounts directly. there will be no beneficiary request that will be facilitated to CPS, and to this extent, a letter has been written to CPS. So his fears were allied, and with respect, the argument was not necessary. As far as Mr. Marcus is concerned, there are two aspects that I must refer to, and that, Your Lord, the court will find in paragraph of this report, which has been commented upon by the panel of experts, but your court will find at 4.19, volume 12, C374, where a process started, where SAPA was given a tender, but the tender had problems. In 4111, SASSA referred the matter to the National Treasury on 1 November 2017 for advice and/or intervention in line with prevailing prescripts on matters of this nature. 4112, National Treasury issued the review outcome on 7 November. The review reflected there were weaknesses in the process followed by SASSA, and that contract went. Then, under 4.2, there's an intervention by the IMC on November 2017. IMC reports, I'll just read this. The IMC has since November 27 committed to align its work to the Constitutional Court reporting requirements. It goes on. In its response, the IMC confirmed the adoption by government of a state-led hybrid model, which included the partnership between SASSA and SAPO, which resulted in the 8 December contract. So that explains when Mr. Marcus is complaining about, well, we already knew in November, and when Mr. Bava refers to something in September, events overtook itself. The second feature of Mr. Marcus's argument, I stated in my opening address, the claim for the 700 million, whether it's a good claim or a bad claim, requires a principal issue, and that is whether you're extending the disgorgement principle arising from the breach of fiduciary duties to a finding by a court in unlawful conduct, apropos a procurement contract is a better, best resolved in the court ARCO, because it has to be by way of action. You've got to join a number of parties, and it's an equity-based case. Personally, I think Mr. Marcus is right, but that doesn't matter. You can't simply transpose that principle here. So that entire argument took up a lot of time. In a nutshell, as far as cost is concerned.
I'm sorry, Mr. Kasim. I thought we were told that your client agrees with paragraph 7 of Fool's Order.
No,
which is the point.
I'm simply saying when it comes to the cost argument.
So do you agree with the paragraph 7 of the order?
If the court is inclined to grant paragraph 7.
No, I'm not asking you. Yes or no, please, Mr.
No, I'm not deviating from the principal stand which I took. It's a matter best to be debated in the High Court. Insofar as the draft order is concerned, on the draft order, as I understood it, Mr. Marcus is not pursuing 9 and 10.
From the expert reports.
That's where you're transferring, you want it to be transferred.
Remove that.
Yes, and then the issue on the draft report, the draft order I want to point out in 5.1, the function in 5.1 is catered for in the directive of 7th November with its monthly reports, and in the order of 17th March where there is 3 monthly reports. I simply point that out. And in paragraph 8, I would have thought that where SASSA has a responsibility, that might be Full's responsibility, because that's really, there's no counterclaim, but it's a cause of action pursued by Mr. Marcus. So on the cost argument, we would submit that, in fact, there was no need to be here other than to persuade the court to give the order by opposition, because they all consented to the order. As the court pleases.
Thank you, Mr. Kasi. Ms. Kasi, please come again. I just, something just registered. No, thank you very much. It's Ms. Kasi that I'm asking to come, not Kasim, Kasi. Ms. Kasi, what is it that the minister is objecting to? What responsibilities is she objecting to in relation to the order? What responsibility is it that she doesn't want imposed on her?
Chief Justice, that is, the reporting obligations are perfectly acceptable to the minister.
They are acceptable.
Absolutely acceptable.
What is unacceptable?
The only, Chief Justice, if I can refer to our supplementary affidavit, unfortunately filed yesterday morning, we did set out those two prayers that we did have concerns with. Mr. Marcus did clarify in his opening that he did abandon the Section 97 relief.
Yes, I thought that was the major one and maybe even the only one.
That is correct, and that was the only one. However, in the way Mr. Marcus has articulated prayer 9 that he would seek now, we have concerns as exactly what the recommendation of that report is and who the decision maker is, whether it would be a parliamentary process under the National Assembly or whether it's a court process, because the recommendation, according to Mr. Marcus's draft, is being submitted to both the court and to the National Assembly, but not to the minister. And so we're not happy with the way...
The recommendation from? My head now
From
is busy.
my apologies, Chief Justice, if I may just pick up my draft order.
You see, I thought the minister is part of the system, so she doesn't have to have anything that needs to be submitted to her flow from a court order. She is very much involved in the affairs of SASSA. Whatever happens there, she's entitled to it. She doesn't need a court order before she could be given any report. So that's what I sought to clear to say.
Then that would be
that would address your concerns.
That would address our concerns, and just the only reason, if I may explain, why the National Treasury directive was of concern to the minister was merely because of those departments or ministries that are involved in the IMC, which is the Interministerial Committee that's really overseeing this process since most recently in their new configuration since November 2017.
Yes.
But no, there's no objection in relation to the rest of the order.
Thank you very much, Ms. Kazi.
As the court pleases.
Judgment is reserved, and the court adjourns